Yes.
Contempt application. Sorry.
Any additional determination has been assigned.
Today,
Why so many advocates waiting for mentioning?
Combined list is approaching.
Yes. Yes.
contempt application for inclusion in the list.
Contempt arising out of the order passed by which
By
court?
Honorable Justice Rabindranath Samanta.
What is the stage of contempt?
This is first time appearing.
Monthly list of March.
Not
Already a lot of contempt matters are there. Yes.
My lord, may I permitted to mention this matter for contempt application?
Arising out of the order passed by
The Honorable Justice Soumitra Chatterjee.
when?
13 June 2018.
What is the stage of contempt?
My lord, this is still unheard condition. So there is no.
Monthly list of March. Yes.
Lordship, may I be permitted to mention a writ petition ready for hearing? An interim order was passed, but that has not been complied with. However, I am seeking that this hearing may be taken up at the earliest. This is
Under which
challenging
group?
Group 9. Lordship, this is Lordship, at the instance of a contractor, the writ petition was filed challenging a debarment order. Now, while the hearing was on, an application was made for issuing a completion certificate temporarily so that I can participate in the tenders. Now, in spite of that order, I have been prevented from participating in tender, and hence I'm seeking that the hearing may be expedited.
But a tender has already been, work order has been issued and the work is complete by the when the writ petition was filed.
Lordship, the writ petition hearing was had concluded.
What is the year of the writ petition?
Lordship, it's of 2018, Lordship. Thereafter, hearing was concluded by the state as well. And Lordship, in reply, I was supposed
What
to.
is the urgency?
Lordship, the urgency
That
is.
upgrade your matter.
Yes, Lordship, the urgency, Lordship. There was an application.
Tender process was complete.
Lordship, I am. Lordship, my.
Work must have been commenced.
Lordship,
Whether it is concluded or
yes,
not, that
Lordship.
is not.
My subject matter is questioning the debarment order, whereby I was prevented from
hand
2
over the
years.
slip. It will be in the monthly list of March. Yes.
Lord, may I be
Sub
permitted
notice.
to mention for upgradation, but with regard to item number 419. My lord, your lordships will remember that last occasion the matter appeared before your lordship in respect of that matter, my lord, who is tortured. My lord, one advocate is tortured fatally.
Yes,
And
it is
yes,
so urgent.
And my lord,
It is so urgent that the matter has, when the matter has been called on, no one appeared.
no, my lord.
Sorry, it will appear in its own court. Sorry, next matter.
My lord, kindly hear me.
Sorry.
for a moment.
Sorry.
Kindly
It
hear
was,
me
it
for-
was, it was called on. Nobody appeared when the matter was called on.
No,
Sorry.
my lord, your lordship
Sorry.
said that the matter will appear in the monthly list of.
Sorry,
budget law.
when matter was
And
called
my
on,
lord-
nobody appeared. It will be taken up in its own course. No special preference. Any man, please don't disturb this court. Yes.
May I permitted to mention one contempt application? Previously, what I mentioned, it was due to appear in the monthly leave of December. Pursuant to my lord's direction, already copy has been served.
Yes, you are mentioning for the inclusion of which contempt?
My lord, in November, my lord, I mentioned this matter. My lord, directed me to serve notice, and my lord, before that, my lord,
You are mentioning for inclusion of under which group?
my
Under
lord,
which
contempt application.
contempt application
Yes.
arising out of the order passed by
Arising
which-
out of order passed by Dr. Sambuddha Chakraborty.
what is the date of the order?
My lord, 16 November 2018, my lord.
And what is the stage of contempt?
My lord, copy has been served. My lord, thereafter, my lord, no, the matter has not appeared, my lord. This stage.
Time.
Yes, my lord.
Dismissed by which court?
My lord, by Honorable Justice. No, sorry. What was those? No. Bharat, Dr. Mr. Bharat, Justice Bharat Daj, my lord.
Hand over the slip, monthly list of February. Serve notice upon others.
Yes.
Lord, may I mention the restoration application arising out of the order passed by Honorable Justice Champa Sarkar on 16/12/2022, my lord. Lord, restoration application was filed within the time. And since the file has got.
Hand over the slip, February monthly list, serve notice.
Much
I beg to mention one matter, my lord. This matter, my lord, for restoration, my lord. this matter was, rejected on 8th of May 23, my lord. Thereafter, I filed an application for restoration. That very application was
Within time,
within, no, my lord, 100 days thereafter.
monthly list of March, serve notice.
One repetition of 2019, Lordship.
March.
This is municipality matter, Lordship. In spite of completion of the work, respondent Bhattacharya municipality is not paying the due amount, Lordship. Even after issuance of the completion certificate. Lordship,
Affidavits are complete.
Lordship, it is, I find it is probably it is motion, at the stage of motion, Lordship.
Motion. Monthly list of February under the heading municipality. Yes,
My lord, may I mention one matter?
just a minute.
May I permitted to mention for contempt matter,
Yes.
contempt application.
Arising out of the order passed by which court?
Honorable Justice Lokita.
What is the stage of contempt?
Four are fresh matter.
Fresh matter. Monthly list of February.
May be permitted to mention contempt application, my lord, arising out of the interim order passed by His Lordship Honorable Justice Soumitra Pal, my lord. Without, my lord, there is a interim contempt.
Monthly list of March. Yes.
Contempt application arising out of order passed by his lordship by her lordship Honorable Lokita Banerjee. 14/2000.
What is the stage of contempt?
New contempt application.
February.
My lord, this is a new contempt application. It is violating the order
Arising out of the order passed by which court?
passed by 26.
By which court? When the order was passed? Violation of which you are complaining of?
Second, KMC.
Ascertain and then mention. Yes.
My lord, may I be permitted to mention one restoration application? My lord, the matter was dismissed for default on 22nd of November 2022. Restoration was filed on 17th of October 2023. There is a delay. Section 5 has been filed along with the restoration application.
Monthly list of March. Serve
My lord, may I
notice.
be permitted
My
to
lord, it has
mention
been
one
completed.
contempt application for the
March
inclusion
monthly
in
list.
the
March monthly list. এটা নিয়ে নেবে. Yes.
My lord, contempt application for the inclusion in the list passed by Honorable Justice Samakti Chatterjee on 16 July 2019.
Monthly list of March.
On motion of 2020, my lord.
So if the advocates are appearing, serve notice upon the learned advocate representing the contemner.
On motion of group 9, my lord, 2020, my lord. Never touched the matter, my lord.
Group 9.
Lordship, matter is lying in file is lying in the court number 9, my lord.
What is the urgency?
Since long matter is pending, I have challenged the circular certificate, my lord. Relying upon that
Monthly
certificate,
list of February, serve notice upon other side.
I have already served, my lord.
Yes. Call the list.
Monthly of February. Grateful, my lord.
Item number 1 from appellate side, Delhi cause list.
Five and 6.
লিখেছেন এখানে? লিখে দিন। File is lying. লিখে দিন। Who is for the state? এই আলাদা আলাদা করে এই অ্যাপিয়ারেন্সটা দেবে। শোনো। At the time of call, no one appears for the petitioner and no accommodation is prayed for. Stop. Same situation prevailed on 10 January 2024. Stop. It appears petitioner has lost interest. Stop. First line টার পর একটা line add করো. State respondents and respondent numbers 5 and 6 are represented by learned advocates. Writ petition stands dismissed. Intimate of any stands vacated. Urgent xerox. Next. Item number 2.
My lord, I appear for the state. My lord, I tried my best. My lord, also yesterday, my lord, I called this recorded advocate and also sent WhatsApp message but no response, Lordship, I have got. But there was.
Have you served notice?
No, my lord.
What is the notice?
No. Brief was,
Why you have not served notice?
my lord, I did not.
I have directed you to serve notice.
My lord, that's
Well,
true,
how many times you have called or not, that I'm not concerned.
my lord.
Why you have not served notice in the order dated 20th December
My lord, since your
2023?
brief was not available with me, that's no difficulty. I could not,
Lot
but
of
I
time
will.
was
I will
given.
arrange, my lord. I will arrange. If your lordship so kindly, my lord.
Whether you have called or not, this was not the direction.
No, that was not.
Then why you have not served notice?
I don't have the brief, lordship, so particulars were not available to me. That's the only difficulty.
If you don't have the brief, why you are appearing?
My lord, I had the brief, but for the timing, my lord,
Don't appear.
I will.
If your client is
I
not
will hear
providing
it,
you the brief, why you are appearing?
I will hear it, my lord.
Only to justify your presence before the court.
No, I will hear it. Give me some, my lord, 3-4 days. This time I will do it.
Issue. At the time of call, Mr. Nayak, learned advocate representing the state respondents, has prayed for extension of time to effect service of notice upon the learned advocate upon the advocate on record of the petitioner, in terms of the order dated 20 December 2023. Stop. List the matter under the same heading for further consideration on Tuesday next, 6th February, Wednesday next, 7th February 2024. In order to enable the learned advocate for the state to serve notice upon the learned advocates for the petitioner.
Grateful, lordship.
Next, item number 3.
Madam, I'm for the petitioner, my lord. On the earlier occasion, your lordship directed me to serve copy upon the non-appearing list. I have served copy, my lord. They are received, but it is being affirmed, my lord. And so, my lord, this is matter of my lord.
Very well, not today. Come back on next Tuesday, Wednesday. Next. Item number 4.
Well,
I am appearing for the petitioner in item number 4.
the respondent number 3 to 5.
I am for 10 minutes.
I am for the petition of led by Mr. Vikas Ranjan Bhattacharya.
Yes, he is online.
Now that this is a clear case of violation of the constitution. I don't think court will have much time to spare.
There is a prayer for adjournment for or short passover on behalf of the respondents.
Oh,
On behalf of the respondents. So therefore, come back on next day. Next week, cooperative society matters are taken up on Wednesday.
Next,
I'm simply making it not today.
next, I have some difficulty because another matter, especially fixed 21st then.
No. Cooperative society matters are
Malad,
taken
then
up on
at-
the Wednesday. It's not possible.
At 2 p.m.
Sorry. Come back. Not today.
At 2 p.m. in the morning,
Wednesday 2 p.m. original side matters are taken up. Once in a week. If you go to if you follow the rider of my list, you will follow each and every day separate matters are taken.
Then your lordship kindly fixed it on 21st, my lord. My lord, because another matter has been specially fixed by just.
When Mr. Sureka will come back?
In 10 minutes.
I am making it Passover. If it is possible, inform Mr. Bhattacharya. If Mr. Bhattacharya can appear, then I will hear this matter today.
Lordship. Okay.
Otherwise, I will take it upon Wednesday. Since I have said not today.
No, I'll inform him.
Yes. Passover. Let me see.
Item number 5.
Item number 5, my lord, I am for the petitioner. My lord, I am for the petition seeking a day's accommodation. My lord, I could not.
Dao.
Pleadings are complete. My lord, this is in relation to, my lord, the disciplinary proceedings.
Yes, what is the matter about?
And the matter is about disciplinary proceedings, and I am not.
Yes, your case.
And I am not ready today.
Sorry, this
I'm
matter
late.
was taken up on 28th December. Then nobody appeared. Then I directed the learned
I have served the notice,
represent the bank authorities to serve effect notice upon you. Either place your case, otherwise I will pass final order.
But I am led by Mr. Ahmed, my lord.
Whoever he may be, if it is possible, place it. Otherwise, I will pass final order. No further adjournment.
My lord, Mr. Ahmed, well, possibly he's contested the election. He told me that day.
Which Ahmed?
Ahmed. He's contested the election, my lord. He was telling that he may be some difficulty, my lord. Kindly.
That is not a ground.
That is not. That is why he did not. That is why. That is why he
request when you will.
He also
that is why I did not say that.
He also requested me, my lord. I said someone should come there and take some time. I cannot.
Not today. Witness.
Yes.
Item number 6 and 7.
When election will be completed?
Second.
Your bar election of bar?
Second.
That is Friday.
Thank you. 6 and 7.
আমাকে দিচ্ছ না আমি আমাকে দিচ্ছ না
Excuse me.
Yes, please, please.
But the concerned cooperative society, my lord, since the tenure of the life of the BOD, my lord, the concerned authority, that is, my lord, ARCS, my lord, has given permission, and my lord, final voter list prepared, but no election was held. Thereafter, my lord, nominated board of directors, my lord, appointed by the, my lord, registrar. The nominated, my lord, here we have challenged, my lord, the nominated board of directors, they are going to, my lord, receive some application for new members, which is beyond the law.
You members of the society?
My lord, we are the members of the society. Our name, my lord, in the final voter list prepared by the, my lord, concerned my lord, cooperative society.
So nominated board of directors is functioning from which date?
Yes, my lord, I am coming.
Where is show me the appointment, induction
induction
of nominated board of directors?
My lord, that not a nutshell, my lord, I have placed the case before leadership, my lord, I am coming. My lord, on 19th 11/20/29, my lord, page 84. Page 84. Annexure P7.
What you have prayed for in the writ petition of
Lord,
0906
My lord.
for conducting 54th annual general meeting.
My lord.
So, if this is your prayer, how you can challenge the move of the nominated board of directors to induct some other persons
My lord, I'm coming.
on the board of directors?
My lord, I'm coming.
Your prayer is 54th annual general meeting to be conducted, to be convened.
Yes. কথা বলতে। My lord, page 16, prayer A.
Of which writ petition?
My lord, the writ petition is, my lord, 5540.
পিটিশনটা কোথাও তো লাস্ট মানে কোয়েশ্চেন আছে আমাদের কমপ্লিট
Yes. Yes.
Man.
So in one writ petition 5540, you have prayed not to induct new members.
Yes.
And in another writ petition, you have prayed for convening 54th annual general meeting.
Man.
Still, this nominated board of directors is functioning.
My lord, I am told that the election has already been held. Because, my lord, so, my lord,
If election is held, then how it is
my
relevant?
lord, it is the submission,
No.
because, my lord, election, I mean.
No. My latest instruction is this, my lord, nominated board has been formed, my lord, lastly on 19th of November 23 for 6 months. That will continue till, my lord, May 24. At least, my lord, this could be, my lord, the observation of my lord. Let the election be held within a reasonable time.
19th November 23 to 18th
3
May.
to 18th of May 24. That's the tenure, that's the life of the present, my lord, board of
Now,
directors.
whether the new incumbents have been inducted as
My
the
lord,
member.
to that extent, my lord, this is a new board, this is a new fresh cause of action. This is not under challenge. Obviously, according to law, in accordance with law, if anything happens contrary to law, my lord, obviously anybody can.
No, show me that this nominated board is authorized to induct new members.
My lord,
Before.
that's the question coming from, my lord, the bar, I believe. Only thing is, I am saying,
No,
my lord,
that is not question coming from the
my lord,
board. That is the prayer
29.7,
recently made in the writ petition.
29.7 of the Cooperative Societies Act, my lord, the nominated board, they will hold all the power, they will assume all the powers, like, my lord, the
Show me
board.
that the nominated board is not authorized to induct new members.
My lord. My lord, in this
And
connection,
one
my lord,
more
I am
thing, lordship,
relying,
I am
Well, hearing.
my lord, I am relying the judgment of coordinate bench of this honorable court, my lord.
Before that, if it is possible, show me the provisions from the relevant act. Show me the relevant provisions first. Judgment will come later.
My lord, I
Swayed by
understand.
the
my lord.
judgment first.
My lord, I understand, my lord.
Yes.
So, my lord,
What is the statutory provisions with regard to functioning of the nominated board?
nominated board, my lord, according to my
Whether
understanding,
the powers and duties of the nominated board is akin to the power of the regular board.
no, there are some, my lord,
So
restrictions.
therefore, highlight that first instead of relying upon a judgment.
One day time.
Yes.
One day time.
No.
Then, my lord, I am relying from the judgment, it will, my lord, reflected, my lord, subject to your lordship's correction.
So, eventually place the judgment.
Before that, may I assist your lordship by saying, by referring the definition of board and nominated board?
2006 Act.
6 Act.
Yes.
Definition 448, lordship, kindly come.
Section
4 subsection H.
Subsection, section 4(8).
8. Clause, subsection 8.
So therefore, according to you, in terms of the definition attributed to the word board, to the term board, nominated board is equally empowered to function as a regular board.
Lordship. This is number 1, and number 2, the special officer also holds the same power, and the administrator also subsequently under section 35, that is your same power.
So there is no exception statutorily.
No
For nominated board is concerned.
no statutory exception, Lordship.
Very good.
Well, it is dealt with by the coordinate bench of this honorable court in view of on the basis of the judgment passed by the honorable Supreme Court.
Very
Lordship,
good.
kindly
Please,
see,
please,
in Ajay Das, in Ajay Das versus State of West Bengal.
Kerala State Cooperative Court Societies Act, their definitions are different. And
Yes,
that way,
yes.
Kerala State Cooperative Societies Act. That was not from West Bengal, not from this West Bengal Cooperative Societies Act. And Supreme Court considered those definitions and not the state power, how power is being distributed. That was dealt with. There it was.
So that is in the context of different statute.
Different statute, different state.
No, this is the judgment which your learned friend is relying upon the judgment of the coordinate bench of this court.
It is not, my lord. It is not.
It has
That
not
is let him place the judgment.
My lord, Lordship, kindly.
Yes. Take me to the relevant part of the judgment.
My lord, relevant part, my lord, second page, last paragraph. The learned counsel for the petitioner refers to a decision honorable Supreme Court in case of Joint Register of Cooperative Societies Kerala versus T.A. Kuttapannam and others reported in so and so, particularly paragraph 7 thereof. Nominated and appointed board of cooperative societies or committees of management appointed by the state are not entitled to induct any member as the same number change the nature and character of society and consequently defeat the cooperative movement. He further submit the order dated 7th August 2018 is an administrative order issued by the registrar intended to frustrate and bypass the order of the Honorable Supreme Court as indicated above. The contention of the petitioner is not devoid of substance. One cannot but notice that an administrative order cannot be used as an indirect route to amend a statute and consequently frustrate a judgment of the Honorable Supreme Court. One should have obtained amendment to the statute or an ordinance introduced in this regard. The same has not been done. Hence, in my view, an administrative order cannot in any way dilute or change the object and purpose of a statute passed by the Register of a Cooperative Society. This court has no doubt in its mind that the said order has been passed to bypass or frustrate the effect of the order of the Honorable Supreme Court. In case of T.A. Kuttapannam, the said order dated 7th August 2018 of the Register shall not be in any effect is hereby state. The learned counsel for the Election Commission also submits that electoral process has commenced sometime in the year September 2018 and the petitioner and other persons has raised objection to the same and some of them also filed nomination and hence the divided from the
আপনার আপনার এই পেশেন্ট এক সেকেন্ড একটু দেখবেন কোনটা ডবল পেজ পর্যন্ত আছে ওকে পেজ
ও এটা এটা এটা
এটা এটা
এটা এটা দেখো না ও
ডবল 40
ওইটা ভাববার জন্য রাখ 3 নম্বর কথাটা কথা বলছি পরে শেষ লাইনে ফাইল অরিজিনালটা থাকছে দিয়ে কর 3 নম্বর Yes, my lord, another judgment, my lord. In this judgment also, my lord, clearly, my lord, mentioned, Lord, you kindly see it to think. Sorry. Page 3, my lord.
কোনটা রেফার করছেন একবার
ওইটা ওই আপনি ওই প্রদীপ কুমার যেটা আপনি ছিলেন প্রদীপ কুমার না
কেস
2000 হ্যাঁ কেস নাম্বার হচ্ছে 766/2020 my lord page 3 my lord there are two issues arose
ম্যাট
না ম্যাট WP 746
হ্যাঁ এটা
এটা দেখা হয়ে গেছে আমার কাছ থেকে
নেন 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 এটা আমাদের কপি
রাখুন আমার কাছে আরেকটা আছে
হ্যাঁ,
এই
তাহলে-
অরিজিনালটা
Yes. Yes.
The order
My
is
lord,
They cannot
received
participate in the
finally.
election.
but I am not arguing on that.
And the fate of induction as nominated members to be decided by the newly elected board.
But only my submission is this in this matter, my lord, that was not the contention to hold election. Now, my lord, my instruction, what I have received with regard to this allegation, my lord, it is position, my lord, register or others, my lord, those who are appearing, they can apprise. But so far the election part is concerned, my lord, election is under process. And
Very well. How many
perhaps-
members have been nominated?
Perhaps 18th of February is the date fixed. In this matter, now, my lord, election is process, my lord, I that will not further any specific program is program to জানা গেছে? This nominated board has been appointed, they are functioning, lordship. This much I can, my lord, enlighten to your lordship.
Yes, Mr. Rahman, how many members have been inducted as new member
My lord, I'm coming.
on
my
the
lord.
board?
I have no instruction on that, lordship.
Some new members. My lord,
Hmm?
numbers, my lord, of that
Okay.
I could not mention in my writ petition.
Where you have stated that the
My
nominated
lord,
members,
yes.
in which paragraph?
My lord, I'm coming.
বলো সেটির কাছে কোনো ইনফরমেশন আছে কিনা দেখো না
Yes, paragraph 12 you have stated.
Paragraph 10, my lord. Paragraph 10.
এর একটা কপি আপনি আমার এক্সট্রা আছে দিন না
কোনটা?
ইনকমপ্লিট এইটা
Writ
এই
petition?
petition টা, এই petition।
আমি তো এক্ষুনি এটা আপনাকে দিলাম।
না দিলাম তো ফেরত
না, আমি নিইনি। আমার কাছে
Okay,
একটা
sorry,
copy আছে।
সরি
ওটাই তো ওই জন্য Because, my lord, we are the general members. So, my lord, it is very much difficult to collect the exact number, how much application they have accepted.
Not so sure.
When the election is scheduled to be conducted?
My lord, to that extent, my lord, I have no information. Only thing is, my lord, the nominated board is functioning. That I have said, my lord, this is the tenure. This is appointed only for the purpose of.
Just now you have submitted that the
No,
election
no,
process
that
is
was
going on and election
that
is
was
going
not
to
on
KL.
record. That is not on record, lordship. Not on record.
No, but you have obtained instruction.
Instruction, my lord. Therefore, the
Show me the instruction.
my lord, running affairs of the society, lordship. My lord, here some marking is here, lordship. Kind. State আছে তো এটা।
ভোটার লিস্ট কবে আছে? ফাইনাল ভোটার লিস্ট মানুষা P6
My lord, sorry for the intervention, lordship.
Just a minute.
Lordship. আছে কিনা ও আছে কিনা এটা তো ইনস্ট্রাকশন কিন্তু একবার আসতে কি আসছেন কে বলবে এটা তো এই কোন খবর আছে তোমার কাছে কোনো মেম্বার্স দিচ্ছে কি নিচ্ছে না
So, in terms of this order dated 3rd November 2023 of the Register of Cooperative Society, first this nominated board was appointed video order dated 19 November 2019.
That is the
yes, that is the first appointment of the
Very well, I'm disposing of these two writ petitions, directing the concerned authorities to conduct election by 18th May 2024 positively upon compliance of all formalities, and the election is to be conducted in consideration of the
final voter list.
Final voter list based on the list prepared prior to 19 November 2019.
My lord, only
And
difficulty is
if any induction of members have been made by the nominated board, the fate of induction shall be decided after constitution of the new board.
My lord, kindly
only
pardon
thing
me,
is,
my lord.
lordship, kindly appreciate.
My lord,
19.
my lord,
My lord,
kindly
19.
pardon
I am
me,
not.
my lord.
19. Lordship, kindly.
My lord, kindly
May not
pardon
be
me, my
disposed
lord.
of today. Only what I am on is. Only on is.
Lordship, kindly pardon me, my lord. The final voter list prepared on, my lord, 12th July 2019, page 56, annexure.
I will not say anything. I will say that what was the position with regard to the members list prior to 19 November 29 shall be taken into consideration while preparing final voter list, and induction of nominated members will not be permitted to participate in the election, and their induction shall be decided by the newly constituted board after election.
My lord, only one submission.
Issue.
No, Lordship, kindly, my lord, appreciate one thing. My lord, from 19, it's a small board. My lord, 19, my lord, might be there are
Nominated members can induct, nominated board can induct members in such a fashion that their desired persons can be elected.
No, only thing is this, my lord, there is.
Nayak, please don't open your mouth too wide. Nominated members can function in such a fashion and induct such persons so that they
I
can
don't
be
know, my
elected.
lord, who are being,
Yes,
who are
yes.
being elected.
Yes.
There has not been any specific allegation to that effect.
Yes, I am not on a specific allegation. Whether the nominated members can do this or not
Right.
in view of the law decided by the coordinate bench.
But Lordship, kindly one. Certainly, my lord, kindly, my lord, pardon me for saying this.
Petitions are taken up for consideration in presence of the learned advocates representing the parties. Stop. Mr. Rahman, learned advocate, representing the petitioners. In both the matter, representing the petitioners, has submitted that in কুলিনগ্রাম ও বেলের ধান্যকুড়িয়া সমবায় কৃষি উন্নয়ন সমিতি লিমিটেড, এটাই পাবে। Herein আপনারা referred to as the said committee, within bracket said committee, quote unquote. Afterটা কেটে দাও। A nominated board was appointed vide order dated 19 November 2019 and for initially for a period of 6 months, and time to time the tenure of the nominated board has been extended. It is also submitted and the same is being corroborated by the submission made on behalf of the respondent authorities that the last extension of the tenure of the nominated board has been made up to 18th May 2024 with effect from 19th November 2023. Petitioners have raised a question has raised a point whether this nominated board during its tenure can induct new members or not. Stop. According to the petitioners, nominated board may function for the administration of the aforesaid committee, but such board cannot induct new members during its tenure, which can change the nature and character of the committee. Stop. In support of such submissions, in support of such contention, reliance has been placed on the two unreported orders of the coordinate bench Roman 1, order dated 15th January 2019, passed in WPA 266 of 2019, within bracket Ajoy Das versus State of West Bengal and others, comma, Roman 2, order dated 17 January 2020, passed in WPA 766 of 2020, within bracket Pradeep Kumar Nath and another versus State of West Bengal and others, close bracket. According to the petitioners, the issue has been decided by the coordinate bench in the aforesaid two writ petitions that nominated board cannot induct new members since the same would lead to alteration of nature and character of the Samiti / society. Next paragraph. The contention of the petitioner is opposed by Mr. Nayak, learned advocate, representing state. Mr. Nayak.
No, I am for election commission, Lordship. For election.
Opposed by the Cooperative Election Commission. Is opposed by Mr. Nayak, learned advocate, representing Cooperative Election Commission, and Mr. Rai, learned advocate, representing state response.
My lord, I would draw your lordship's attention under section 32.
According to the respondents, in terms of section 4 within bracket 8, the definition of board, quote unquote, the definition of board has been attributed, and that will lead to a situation and interpretation of such definition would lead to a situation where no difference is carved out in between functioning of elected board and nominated board in a society / Samiti. Therefore, according to the respondents, nominated board is empowered to function in similar fashion as that of the elected board, and the elected board semicolon. Therefore, there is no anomaly so far the nominated board is concerned in the present case. If new members have been elected, if new members have been inducted by the said nominated board. Stop. Next paragraph. Having considered the submissions made on behalf of the respective parties and on perusal of the relevant records available, on perusal of the relevant materials available on record, it appears that it has already been decided by the coordinate bench in Ajoy Das Supra and Pradeep Kumar Nath Supra upon placing reliance on the judgment of the Apex Court reported in 2000 volume 6 SCC 127 within bracket Joint Register of Cooperative Societies Kerala versus T.A. Kuttapan, K-U-T-T-A-P-P-A-N, Kuttapan and others, close bracket, that nominated members, that the nominated board cannot induct new members since that would lead to changing nature and character of the society or Samiti. Since this court is considered, it is also recorded in Ajoy Das Supra that since it is also decided, it is also recorded in Ajoy Das Supra. It is also decided therein that in the case of Samobai Krishi Unnayan Samiti, the authorities should be more alert and vigilant with regard to functioning of nominated board, since it should not function in a fashion by inducting new members that could alter the nature and character of the society. Stop. Relevant part of the order dated 17 January 2020 passed in Pradeep Kumar Nath Supra is quoted below. এই দেখো সেট আউট করে দিন। Next paragraph. The object of the statute governing the affairs of cooperative societies is to and cooperative society is to constitute an elected board to administer a particular society. Stop. Instead of elected board, when a nominated board is inducted to administer the said society, it is desirable that the said nominated board should not act in a way which can alter the position relating to the members of the said society which was existing prior to induction of the said nominated board, since that may entirely alter the situation, which would have a negative impact on the democratic process of holding election to constitute a new board. Stop. ঠিক করে লিখেছে তো, এটা গন্ডগোল করে ফেলো না। Stop. Next paragraph. In view of the aforesaid discussion and the decisions of the coordinate bench dated 15 January 2019 and 17 January 2020, it is directed that the nominated board will hold the election for reconstitution of board, reconstitution of board of the aforesaid committee.
My lord, sorry, my lord, board cannot hold election. Election commission will hold the election. My lord, board will support, will assist. My lord, will assist the election commission.
আবার সেন্টেন্সটা পড়ো না, is directed that the concerned authority will hold the election for reconstitution of a new board within 18th May 2024 to 18th May 2024 on completion of all necessary formalities.
My lord, one small submission can I make, lordship? Since my lord, though it is not on record, my lord, election of the parliament election is on board. My lord, that time the officers, the few officers, those were working handicapped with little number of officers. some more time may kindly be given.
That will lead
But
to a
3 months is
situation
required. 3 months.
that will lead to a situation which will extend the tenure of the nominated board. The present tenure of the nominated board is up to 18th May
No,
2024.
when election commission is coming into the picture, Lordship, they will take up all the charges. Board will not do any, will not take any policy decision or anything. Election commission will be under the control of the election commission, and they will be assisted with the highest paid employee or Milord. That may kindly be Milord clarified, otherwise to avoid contempt.
Since an order dated 3rd November 2023 is placed before this court. Now, since the order dated 3rd November 2023 of the Register of Cooperative Societies, West Bengal is placed before this court, wherefrom it appears that the tenure of the nominated board has been extended up to 18th May 2024. Stop. The said order dated 3rd November 2023 of the Register of Cooperative Societies, West Bengal is taken on record. Stop. Next paragraph. It is also made clear that while conducting election by the concerned respondent authorities, the list of members which was existed prior to 19th November 2019 shall be taken into consideration in preparation of the final voter list, excluding the members who have been inducted by the nominated board. Nominated board. Stop.
Under section 32 subsection 6 will come into force, Milord, because if no director who has been an office bearer.
Stop. After the election is conducted, the newly constituted board shall take a call with regard to induction of new members by the nominated board. In their first general meeting, it is decided in the general meeting.
Milord, after the portfolio of officers, Milord, the election being held, Milord, they are entitled to
hold a general meeting.
So, Milord, they can take it
In the first general meeting or in its first general meeting. Stop. Next paragraph. Mr. Naik, learned advocate representing West Bengal Cooperative Election Commission, submits that there might be a requirement to defer the election if the notification is issued for holding the general holding the parliamentary election in 2024.
Lordship.
Stop. If situation so arise, the West Bengal Cooperative Election Commission shall approach this court for extension of time to hold the election of the aforesaid Samiti. Stop. Next paragraph, with the aforesaid directions and observations, both the writ petitions stand disposed of. There shall be no orders to post or application, comma, if any pending, also stands disposed of.
Grateful, Lordship. ওই কপিটা না ওটা থাক ওটা আছে আপনার কাছে আমার কাছে ইনকমপ্লিট কপি আছে থ্যাংক ইউ জানি না আছে 16টা পেজ এসছে আর পেজ নেই
অনলাইনে শেষ হয়
করা যাচ্ছে না কিছু না তা আপনিও দিচ্ছেন না
আপনি আমাকে বলবেন
Item number 4, possibly Mr. Bhattacharya is online. Mr. Craig has come.
একটা দুটো 1 মিনিট তুমি ধরে করে নাও না ইলেকশনটা করে নাও এটা দিয়ে দাও বিকজ আর স্পেস চলে যাবে
Let two other matters be called on and then it will be taken.
Item number 8.
Yes,
My lord,
you are appearing for the petitioner.
for the petitioner. So this is a cooperative housing society, my lord.
But I appear for election commission.
All the parties are present.
This is a cooperative housing society, my lord. The election of the last board of directors was held in the year 2014. Now, this is the dates are very important. 2014, the last election was held.
Just a minute.
No, she's out. So out. There will be nothing.
Who is representing respondent number 7? Yes, Mr. Sapoti.
My lord, respondent 7. This is change. My lord, I don't know who appeared at that point of time, but I am told.
Mr. Sarwar Jahan and Maidul Islam
I am
appear.
told.
So you have said that all are represented?
I appear for election commission, Lordship.
Sir, notice upon respondent 7.
I am told that respondent 7 is
Register
no more.
appear for sir.
I think he has expired.
Respondent 7 is no more.
No more. I am told.
So then you have to make an application for substitution.
Because this is not that
Very well, you serve notice upon the learned advocate representing respondent number 7. Mr. Sarwar Jahan appeared for the respondent number 7. He is a practicing advocate of this court, sits in court now, bar session room number 13. Issue. The writ petition is taken up for consideration when the learned advocate representing the petitioner has prayed for accommodation to effect service of notice upon the non-appearing respondents. Stop. Next paragraph. The learned advocate for the petitioner is directed to serve notice upon the respondents or the learned advocates representing those So, directed to serve notice upon the non-appearing respondents or the learned advocates of those respondents, enclosing copy of the order passed by this court today by by 5th February 2024 and file affidavit of service on the adjourned date. Stop. Next paragraph. List the matter under the same heading for further consideration on 7th February 2024. Next.
Item number 9.
My lord, Mr. Shoykot Chatterjee is appearing for the respondent bank, my lord. My lord, he's having a doctor's appointment, my lord.
Always he has some problem. Same matter.
No. This is another matter.
What is the matter about?
Matter about the leave salary 180 days or 300 days. Our court already held that after amendment 300. Only issue. Earlier 2 occasions your lordship also directed to file affidavit, not yet file affidavit.
Affidavits are complete.
No, your lordship directed on 20th December also.
Yes.
Directed twice.
Why the affidavit has not been filed? Well, not today, since he has personal difficulty. Simply not today. Call the passover matter. Item number 4, passover matter.
My lord, I am for the petition, my lord. I am led by Mr. Bikash Ranjan Bhattacharya, my lord, senior advocate.
Society.
My lord will kindly turn to page 59.
Record has not been placed before me, Mr. Bhattacharya.
I thought this coast is so fast. The record is not in there.
It's 59.
Now the petitioner's application was refused. Kindly come to paragraph 2.
Just a minute, Mr. Bhattacharya. I have passed one order previously. Let me go through that order and then I will.
Okay.
Yes. Mr. Sureka, last occasion you
I had placed an order.
Just a minute. This is order dated 16 March 2020.
2020, my lord.
Yes, Mr. Bhattacharya.
Now, my lord, these are all unnecessary exercise because this is per se unconstitutional, per se against the statute. I don't think that the registrar ought to have given somebody a chance to prolong the matter with these illegal bylaws. My lord will straightway, my lord, set aside this particular clause.
Place the facts in a nutshell in order to grasp over the issue.
My lord, basically, their bylaw says
We have
that
a tendency, Mr. Bhattacharya, to place in a very short campus that may create problem at the hearing stage.
this is a, my lord, the society which, my lord, they have their own bylaws. Bylaws must be in tune with the constitution and this act. My lord is well aware that the constitution amendment was made bringing cooperative society within the purview of the constitutional organization. And accordingly, all the acts of every state were amended. Here, the West Bengal Cooperative Societies Act 2006 was amended. This was done for the purpose of development of democratic cooperative societies. And there, everybody, every citizen has the right to participate and become a member. That's the foundation of the 2006 Act in terms of the Constitution. Now, they have a bylaw which says that only Hindus can be a member. That this particular clause is not ultravirus to the statute and the Act Constitution. I don't have to argue anything more.
But whether the case has been made out in the writ petition? To
Yes,
that
yes. That's
Where?
the case. That's why I have pointed out the annexure. Kindly come to page 58.
No, where is the prayer? Where is the prayer, Mr. Bhattacharya?
Kindly come to the prayer is that they must be made member by transferring the property. Kindly comes to the prayer. To withdraw, modify the order dated so and so, and set as the decision of the society, which speaks of that you can't get it because you are not a Hindu. The day, though may not know where was made.
Society dated 17th December 2018.
Yes. 17 December 2018 is at page
58. Page 58.
58.
Annexure P7.
Annexure
Yes.
P7.
And the clause 12(2) of the said decision.
Okay.
Paragraph 2 of the at page 59.
So no prayer is there.
No,
The
there is
basis-
no prayer is below to set aside that decision.
The virus of that bylaws of this particular housing society has not been put under challenge on the context of constitutionality of that bylaw.
But even if that is not challenged, now it is before your lordship being a constitutional court, my lord finds that a particular clause which is per se unconstitutional. Therefore, the constitutional court will not keep its confined only the parameters of the prayers made. If something is unconstitutional, the court will say unconstitutional, whatever might be the consequence. That's my humble prayer. Therefore, the court can also modify the prayer, my lord, depending on the pleadings of the parties. That is all settled position.
Now, apart from this, you are attacking the relevant part of the bylaw whereby the inclusion of the members in the society is restricted to Hindu Bengali.
Yes, that is only.
Bengali only. That is not the law of a legislature. That is the law of a society, cooperative society, that has been framed in terms of the relevant particular power entrusted upon the society. Now, this law is in force from for a long period of time.
1952.
1952. Now, everybody has accepted the same. Now, in the now while the inclusion of the pro forma respondent as a member of the cooperative housing society has been spurned, now this writ petition has been filed challenging the decision of the cooperative society without lodging any challenge against the constitutionality of this bylaw. So therefore, how your contention can be accepted at this stage?
Sir,
may I make
in the absence of any case made out to that extent?
Sir, kindly.
May I just point out to your lordship?
Chakraborty.
Now, my lord, these bylaws is pursuant to the old act, when the constitution did not permit the cooperative society to be a constitutional body. With the amendment of constitution, my lord was well aware. Now, under Article 19, the cooperative society is also a body which should be formed under the constitution. The 2006 Act has come. Therefore, any law which is now contrary to Act 2006 is bad. Whether somebody is challenged or not, that was the duty of the society and the cooperative authorities to ensure that everything is done in terms of the present Act of 2006. And when this is per se unconstitutional, well, that I challenge because but when I suffer, that if somebody doesn't suffer, he can't come to court.
Not challenged in the writ petition.
Now, well, I have challenged the decision.
I could have, Mr. Bhattacharya, there is no challenge.
No,
There
the
is
challenge is
challenge.
the challenge is to the extent that the decision is ultra vires.
Your submission and argument is very catchy. It always remains catchy. So far, Mr. Bhattacharya's argument is concerned. But in absence of challenge, how your submission can be appreciated?
Very well. But that is the difficulty. I shall amend the petition. Kindly take it up with the next week. I shall amend the petition.
At this hearing stage?
Yes, at every stage. When the amendment can be done.
Mr. Bhattacharya, withdraw the writ petition, file afresh. Because I have heard this matter on number of occasions. Now at this stage, I will...
Kindly then will not give me liberty to withdraw with permission to file afresh.
That I have to.
My lord.
If you make this prayer.
May I Sir, kindly.
I will not permit any conference online.
Rule 13. Rule 13 says when there is a conflict between the act and rules and the bylaws.
Mr. Bhattacharya has already submitted that let the writ petition be dismissed as withdrawn with liberty to file afresh with better particulars. So are you?
No.
Can you make a different submission?
Not at all, ma'am.
Esho. The writ petition is heard when Mr. Vikas Ranjan Bhattacharya, learned senior advocate representing the petitioner, submits that the petitioner does not want to proceed with the writ petition, submits that the petitioner wants to withdraw the writ petition with liberty to file afresh. Stop. Next paragraph. Such prayer has not been opposed by the learned advocates representing the respondents. Stop. Next paragraph. Having considered the submissions made on behalf of the petitioner, the writ petition stands dismissed as withdrawn with liberty to file afresh on the same cause of action. Stop. There shall be no orders to cost urgent xerox certificate copy. Yes, Mr. Yes, next matter. Yes, you are opposing.
I am the respondent number 6. It is my interest which is really affected. Now, I just wanted to put in something from the writ petition as also stated.
So therefore, at line ta kete dao to yeah. Yes, very well. I have deleted that submission of the respondents. Then you are safe. If petitioner doesn't want to proceed with the writ petition, wants to have the same withdrawn. Yes. (856).
Item number 856 from appellate side, monthly cause list.
Mr. Sueka, that is the only escape route. Also, it struck my mind when I saw these provisions of bylaws.
Your Lordship, but
Constitutionality of the bylaws is, if it is challenged, then you have a difficulty.
Your Lordship, but there is possibly a Supreme Court judgment regarding Zoroastrian society.
Really, you will fight it out before the bench.
This criteria cannot be there.
I'm for respondent number 5.
Yes. এই এক মিনিট শোনো। Virtual mode. No, return the petitioner appears on virtual mode and submits. Yes. Yes. Who is for the petitioner?
Well, I'm for respondent number 5 and 6, my lord. We have
That
to,
matter.
well, we have to instructions. So, my lord, the affidavit opposition we did not
Last
file.
occasion you did not appear,
Yes, my lord.
and today petitioner is not represented. State was there, petitioner was there. Last occasion you did not.
Yes,
You are the
ma'am.
respondent number 5.
5 and 6, my lord. The authorities have changed, so
Get the applicant to approach the newly elected. That they have approached or not.
No, no. Perhaps you are
Sorry.
you are reading some other order.
In order to give one more chance.
We will let a chance be given to the petitioner instead of dismissing the matter. Because petitioner is, I remember that there was a contest in between the petitioner and the respondent number 5. You have taken out an application for vacation of the interim.
vacation.
That was heard and disposed of, and the interim order was allowed to remain in force till the disposal of the writ petition. Record and order. At the time of call, no one appears for the petitioner and no accommodation is prayed for. However, state respondent and the respondent number 5 are represented by learned advocates. So, in order to give one more chance to the petitioner, hearing of this matter stands adjourned till Wednesday next 7th February 2024, when it will appear under the same heading. Next paragraph. The learned advocate for the respondent number 5 is directed to serve notice upon the learned advocate for the petitioner by
By hand, we
February 2020. Serve a notice.
এটাকে আমি তাহলে দিতে পারবো। সুপ্রিম কোর্টের রিট গ্র্যাচুইটি জাজমেন্ট যেটা আপনি নোটও করছিলেন ডাউনলোড।
Item number 857.
I am for the employer state cooperative bank.
My lord, I am appearing on behalf of the state, my lord, Mr. Pritam Chaudhary appearing in this matter, my lord, kindly make it not.
Yes.
Mr. Pritam Chaudhary out of.
We are appearing for the state.
Yes.
আমার কোনো অসুবিধা নেই, ঠিক আছে, আমরা কোনো
Last occasion when this matter was taken up, Mr. Chaudhary prayed for time. He has some.
Well, I say I'm the last person, Milord, kindly, Milord, but I have what I could, I just, yes, Milord.
Yes, yes.
Yeah, Lordship wanted a short list of dates. My client is very enthusiastic in his efforts. He has prepared a list of dates.
But you should have a glance over them.
That's right. And what he did for the entire matter, what are the points which I have to.
Enthusiasm is good, but professionalism is another thing.
So there I told you, Lordship, that insofar as this matter is concerned.
You are there and it's a service matter.
No, I have to
much
do it.
cherished subject. So therefore you should go through the same and.
No, I have read the particular points which he has canvassed. There is no dispute. I am also raising the
Prepare
same.
it in the proper formatization.
That's the formatization.
I have just seen which you have just shown to me. So it needs to be formatized.
I'm grateful.
Not today.
Yes, only not today. Let it be taken any day.
Next Wednesday.
Yes.
Wednesday, Cordusity matters are taken up.
I will not be taking more than half an hour.
My lord, I shall make submissions on merit as well as on maintainability, my lord.
Yes,
That I had indicated before your lordship on the earlier occasion also. My lord, I shall have to try to place the judgment of Bhavani Adhikari matter.
State cooperative bank.
Yes, my lord. The Bhavani Adhikari judgment of honorable
have
division
already
bench of our honorable
decided in another case in a cooperative society matter.
my lord, I shall rely upon paragraph 29 of that judgment in context of the earlier rule of
When your turn will come, you will raise this issue. But I will not permit you to argue on this preliminary point at a threshold. Because
Yes, my
I have
lord, I
already
shall argue.
decided, Mr. Sureka was there in other matter, in cooperative society matter, whether the identical point was taken up with regard to maintenance.
My lord, I shall place.
And it is against the West Bengal State Cooperative Bank. So therefore, this point I don't think
Subject to kind approval of your lordship, my lord, I may make submissions on this point of maintainability at the later stage, my lord, not at the initial threshold stage.
Record an order for Mr. Arnob Rai. The matter is taken up for consideration in presence of the learned advocates representing the petitioner, bank authority and the state respondent. Stop. Accommodation has been prayed for on behalf of the state respondents, since the learned advocate representing the state respondents has not come to court due to personal difficulty. Next paragraph. Mr. Bhattacharya, learned senior advocate representing the petitioner, petitioner submits that a list of dates and synopsis of the facts. A list of dates and written notes.
Yes.
List of dates and written notes shall be filed on the next page. Next paragraph. List the matter under the same heading for further consideration on Wednesday next, 7th February 2020.
I'm extremely
grateful to your lordship.
Item number 858.
20,000 থেকে কোথায় গেল? ও হ্যাঁ হ্যাঁ আইটেম নাম্বার 864 এগুলো সব হয়ে গেছে। আইটেম নাম্বার 864
My lord, I am for the respondent number 4 and 5.
Very good.
My lord,
Just a minute, just a minute. At the time of call, no one appears for the petitioner.
my lord, this is, in earlier occasion, an order was passed for exchange of affidavits.
Yes.
I admit my lapses, like I could not submit the same at the proper time. Kindly allow me some time.
It's not required. Let me see whether the petitioner is interested at all or not.
No, that is
They should hear the order of the court. At the time of call, no one appears for the petitioner and no accommodation is prayed for. However, state, you are for the state. I have a state respondents and the respondent number 5 are represented by learned advocate. Next paragraph. It appears video order dated 6th August 2019. A coordinate bench directed the parties to exchange affidavits. Stop. Writ petition needs to be treated as hearing matter. Stop. Next paragraph lists the matter under the heading hearing cooperative society for disposal on 7th April 20 on 7th February 2024. Stop. However, it is made clear if on the urgent date petitioner goes unrepresented, consequential order shall be passed. Amit asini naki? That guy the second of province. 865. Next.
My lord, I appear for the election. But in this matter, my lord, what I was saying, due to inadvertence, the applicant was directed to make a press application before the board to take up the matter for taking step. That is in the before penultimate paragraph. You must understand.
So whether the writ petition was disposed of?
No.
Here the board's decision to be communicated to your lordship. That's
who is appearing for the board?
Board appears. And petitioner is also to communicate that was not the petitioner.
Nobody is appearing for the petitioner.
My lord.
If you, I can direct you to serve a notice upon the learned advocate for the petitioner. Mr. Amitabh Mukherjee, Soumi Chando, Ankita Ghosh appeared. Very well, come back. Yes.
They can also, my lord, they can also serve.
I shall.
Why you cannot serve?
I failed, my lord. That's why
You're passing the buck to Mr. Kurek.
my lord.
In the morning, I have
Yes,
I have noticed
my
that you have failed to serve notice.
lordship. And I have been,
Punishment you have to serve.
my lord. My lord.
Yes. At the time of call, no one appears for the petitioner and no accommodation is spread for. Stop. However, you are for the state.
I'm for this.
I have for the register, lordship. Register.
Yeah, for the register, corporate
Lordship.
society. Just a minute. You are for the state.
Your Lordship, I am for
Register and joint register, you are representing.
Lordship.
However, state respondent and respondent numbers 2 and 3 are represented by learned advocates. Stop. Next paragraph. List the matter. Next paragraph. By order dated 24th February 2022, a coordinate bench directed the parties to exchange affidavits. Stop. The writ petition needs to be treated as hearing matter. Stop. Next paragraph. List the matter under the heading hearing cooperative society for disposal on 7th February 2024. Stop. The learned advocate for the respondent number 2 and 3 is directed to serve notice upon the learned advocate representing the petitioner, enclosing copy of the order passed by this court today by 5th February 2024. Stop. Have a notice.
My lord.
Next.
Otherwise, I will have to relinquish my right to appeal, Lordship.
Yes.
Grateful, my lord.
866.
My lord, I am for the petitioner. In this
Yes.
The case is, my lord, that in 2001, the Sundarban Development Board.
Sundarban Development Board.
Yes.
Whether the affidavits are complete.
No, my lord.
You don't want whether the state wants to file an affidavit. Was there any direction? Yes, there was a direction to file affidavit.
Yes, my lord. There is a direction to file affidavit.
Mr. Rai, do you want to use any affidavit?
Lord, they are the concerned respondents.
He is for the petitioner.
Sundarban.
Sundarban Development. You are not representing Sundarban Development. Your grievance is against Sundarban Development Board.
Yes, my lord.
What is your grievance?
Grievance, that is the Sundarban Development Board issued an order to the petitioner society for supplying moong dal seeds.
Yes.
Moong dal seeds, my lords, to its different growth centers of Sundarban. And accordingly, the society petitioner is the state level organization. It issued an tender, and after processing the tender, it was decided to pass an order to the global nursery for supplying the same to the
Global Agri Horticulture Agri Horti Nursery.
Yes, my lord.
Respondent number 4. Yes.
And accordingly,
who are you?
I am for the West Bengal State Cooperative Marketing Federation.
How they are in how their right is affected?
Yes, my lord.
How the right of the marketing cooperative federation is affected?
Right, that is because Sundarban Development Board did not pay the for the said supply to the federation.
It's supplied by you.
Yes.
Or the pulses supplied by you.
Yes, my lord.
Pulses supplied by you.
Seeds. Moong dal seeds. Yes. Supplied.
So pulse seeds supplied by you.
Yes.
But no, it has no payment.
Yes, my lord.
This is a money claim.
Yes, my lord.
It's a money claim.
Money claim.
Money claim, how the writ petition is maintainable. There's a judgment of the Supreme Court, you come ready that in the case of money claim, unless and until respondent admits the same, writ petition is not maintainable.
No, my lord. My submission is this: it was filed before the dispute case, and dispute case in the arbitrator passed the award, and subsequently it went to the tribunal.
Award in your favor.
Tribunal passed the order, and subsequently.
What was the order passed by the tribunal?
Passed by the tribunal, passed by the learned arbitrator that that payment should be made by the Sundarban Development Board directly to the agro horticulture services, and not to the society.
But the seeds have been supplied by the petitioner or by the respondent?
By the petitioner, my lord. Passed pass order to the
You have challenged the order of the tribunal.
Order of the arbitrator, and also that which was confirmed by the tribunal.
So,
So
you have challenged the order of the first authority and the tribunal.
yes, my lord.
2 and 3.
And
Tapon Kumar Pal appeared for 3 and Rajat Datta for 4.
yes, my lord.
You served notice
In
upon
earlier case, the Sundarban Development Board. My lord, only one thing.
The writ petition is taken up for consideration in presence of the learned advocates, who is for the state. Learned advocates represent
My lord, there will be suppression of facts.
petitioners and the state respondents.
My lord.
Stop. However, no one is representing respondent numbers 3 and 4, though petitioner has grievance against the respondent number 3 and 4. Stop. Next paragraph. There is a direction. Next paragraph. By order dated 6th August 2019. By order dated 6th August 2019, a coordinate bench directed the parties to exchange affidavits. Stop. Writ petition needs to be treated as hearing matter. Stop. Next paragraph lists the matter under the heading hearing cooperative society for disposal on 7th February 2024. Stop. However, next paragraph, the learned advocate for the petitioner is directed to serve notice upon the non-appearing respondents or the learned advocates for those respondents, including copy of the order passed by this court today by 5th February 2024 and file affidavit of service on the adjourned date.
My lord, there will be a suppression of fact on the part of me. In earlier case, that is the case of 864, Sundarban Development Board also challenged the order of the arbitrator and tribunal in the previous case.
Very well, let me hear you on the next date. If it is necessary, that matter will be tagged, but not today.
Yes, my lord.
Yes.
Mata.
$867.
You are for the state.
But for 67 lots, we appear for registrar.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. However, state respondents and the registrar of cooperative society are represented by learned advocates. So, registrar of cooperative societies are represented by learned advocates. Stop. Next paragraph. List the matter under the heading motion cooperative society for disposal on 7th February 2024. Next paragraph. However, it is made clear if on the adjourned date petitioner goes unrepresented, consequential order shall be passed. Next paragraph. The learned advocate.
Lordship. And Mr. Sureka and Mr. Das.
For the registrar.
Lordship.
You are for the state.
No, I'm for the register. He is having for the state.
The learned advocate for the state respondent is directed to serve notice upon the learned advocate representing the petitioner, enclosing copy of the order passed by this court today by 5th February 2024. Stop. Service. Next.
868.
Thank you. No. Ashun. You are for the state and
for register, Lordship.
Register code of society.
Lordship.
But register is not a party.
Not party. SN register, Lordship.
No. Only state of West Bengal and then private parties.
Lordship. Then
Milk Producers Welfare Association,
Lordship,
then president of the association, assistant
Lordship.
secretary of the association. So only state is there.
Lordship.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. However, state respondent is represented by learned advocate. Next paragraph. List the matter under the heading motion cooperative society for disposal on 5th February on 7th February 2024. Next paragraph. However, it is made clear if on the adjourned date petitioner goes unrepresented, consequential order shall be passed. Next.
869. এটার নামটা দেখ আগেরটা
4 and 5. 4, 5, 6.
Who is for the state?
Your Lordship, I am for the respondent bank.
Should I be for 4, 5 and
With
6?
the what is Sharadaboli Cooperative Bank, you are representing. And registered code of society?
4, 5 and 6, Lordship.
Ashun. At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. However, state respondents, comma, respondent number 4, 5 and 6 and the bank authority are represented by learned advocates. Appearance gulo oiভাবে দিয়ে দেবেন. Next paragraph, list the matter under the heading motion cooperative society for disposal on 7th February 2024. However, it is made clear if on the urgent date petitioner goes unrepresented, consequential order shall be passed. Next.
Item number 870.
State you are appealing. District register code of society. Ashun. At the time of call, no one appears for the petitioners and no accommodation is paid for. However, state and the register of cooperative societies are represented by learned advocates. Stop. Next paragraph, list the matter under the heading motion cooperative society for disposal on 7th February 2024. Stop. However, it is made clear if on the urgent date petitioners go unrepresented, consequential order shall be passed. Next.
871.
Additional register of cooperative societies. Then deputy register is also party.
My lord.
Assistant register you are representing. State is not a party.
Right.
Ashun. At the time of call, no one appears for the petitioner and no accommodation is paid for. However, Respondent numbers 1, 2, and 3 are represented by learned advocate. Next paragraph lists the matter under the heading Motion Cooperative Society for disposal on 7th February 2024. Stop. However, it is made clear if on the adjourned date petitioner goes unrepresented, consequential order shall be passed. Next.
$872. Two, 3. What is it?
Bank you are representing.
Deputy
Bank
Registrar
and
Lordship.
State.
3.
You are representing 3.
Lordship.
Ashun. And state you are representing. At the time of call, no one appears for the petitioner and no accommodation is prayed for. However, state respondents, bank authority and respondent number 3 are represented by learned advocates. Stop. Next paragraph lists the matter under the heading Motion Cooperative Society for disposal on 7th February 2024. Stop. However, it is made clear if on the adjourned date petitioner goes unrepresented, consequential order shall be passed.
Item number 873. Want to see the এটা না এটা হবে না
Group 9 now.
Oh, secretary operation.
Perhaps it would be group 9.
No. Cooperation department is
Not a
one.
party, but
Let them
Minister
let
of-
petitioner come.
It is under the West Bengal Society Registration Act.
One low
So
Lordship
it's
here.
not a cooperative society matter.
I appear for the Milord. Yes.
And in the presentation form, there is an amendment. Group 5 has been struck off and group 9 has been inserted.
Right. I appear for Milord 1.
Wrongly
One is
placed.
secretary cooperation department. I appear. That's why Milord, I was asked to appear for 1. Having no role, maybe.
Ashun. No one appears for the petitioner and no accommodation is prayed for. So, however, no accommodation is prayed for. You are appearing for whom?
Secretary cooperation department, Lordship. 1.
However, respondent number 1 is represented by learned advocate. Stop. Next paragraph. On perusal of record, it appears that in terms of the order dated 30 March 2022 passed by a coordinate bench, presentation form of the writ petition has been amended Thereby, the writ petition has been classified as Group 9 matter. Stop. Next paragraph. Accordingly, the writ petition stands released due to want of determination and be placed before the appropriate bench. Group 9, I have determination.
Lordship.
Just a minute.
My lord, in some
Which we are-
matters, my lord
No,
is having
2021 I don't have. I have up to 2018.
2020.
2020.
2020.
Respectfully, Your Lordship.
Released. Panchayat matters. Yes, call
Grateful,
Panchayat.
lordship. My lord's kindly.
Combined list. Combined list চলছে। কত থেকে ডাকবে? 420. ইন্ডিকেশন আছে তো আজকের লিস্টে 420 থেকে ডাকা হবে আফটার এক্সস্টিং দেখো right? Call Panchayat matters.
Item number 420, Panchayat matters from appellate side monthly cause list. Panchayat matters, item number 420.
At the time of call, বসেই লিখে নিন লিখতে হবে না। At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. Next paragraph. List the matter under the heading motion group 5 within bracket group 5 panchayat for disposal. Quote unquote দেবেন পুরোটা হ্যাঁ। Motion থেকে for disposal on February 7th, 2024. However, it is made clear, next paragraph, however, it is made clear if on the urgent date petitioner goes unrepresented, consequential order shall be passed. Next.
421.
At the time of call, no one appears for the petitioner and no accommodation is paid for. Next paragraph. List the matter under the heading motion group 5 panchayat for disposal, quote unquote, on 7th February 2024. Stop. However, it is made clear if on the urgent date petitioner goes unrepresented, consequential order shall be passed. Next.
Item number 422.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. Next paragraph lists the matter under the heading motion group 5 Panchayat for disposal on 7th February 2024. Stop. However, it is made clear if on the urgent date petitioner goes unrepresented, consequential order shall be passed. Next. 423. At the time of call, no one appears for the petitioner and no accommodation is prayed for. Next paragraph lists the matter under the heading motion group 5 Panchayat for disposal on 7th February 2024. However, it is made clear if on the urgent date petitioner goes unrepresented, consequential order shall be passed. Next. 424. At the time of call, no one appears for the petitioners and no accommodation is prayed for. Next paragraph lists the matter under the heading motion group 5 Panchayat for disposal on 7th February 2024. Stop. However, it is made clear if on the urgent date petitioners go unrepresented, consequential order shall be passed. Next. Item number 425. At the time of call, no one appears for the petitioners and no accommodation is prayed for. Next paragraph lists the matter under the heading motion group 5 Panchayat for disposal on 7th February 2024. Stop. However, it is made clear if on the urgent date petitioners go unrepresented, consequential order shall be passed. Next. 426. At the time of call, no one appears for the petitioners and no accommodation is prayed for. Next paragraph lists the matter under the heading motion group 5 Panchayat for disposal on 7th February 2024. However, it is made clear if on the urgent date petitioners go unrepresented, consequential order shall be passed. 427. At the time of call, no one appears for the petitioner and no accommodation is prayed for. Next paragraph lists the matter under the heading motion, Group 5 Panchayat for disposal on 7th February 2024. However, it is made clear if on the adjourned date petitioner goes unrepresented, consequential order shall be passed. Next.
428.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. Next paragraph lists the matter under the heading Motion Group 5 Panchayat for disposal on 7th February 2024. However, it is made clear if on the adjourned date petitioner goes unrepresented, consequential order shall be passed. Next.
429.
My lord, I beg to appear for the petitioner, my lord.
Yes.
In 2000, my lord, the petitioner, my lord, participated in a selection process for, my lord, appointment of Panchayat Sahayoks in Dhupguri block in Jalpaiguri. My lord, written test
What was the date of what was the year of selection
my lord,
process?
2000 initial selection process was initiated. My lord, thereafter, my lord, written test was held on 22nd of October 2000. And my lord, I came out to be my lord, the first, the candidates obtaining, my lord, highest mark in that written test. My lord, subsequently, call letter was issued for interview, and the interview was scheduled on 1st of September 2001.
But how this writ petition is maintainable after 16 years?
My lord, thereafter, one my lord, writ petition was filed. Pursuant thereto, my lord, the selection process was freshly conducted by the newly constituted, my lord, district level selection committee. That was, my lord,
when that writ petition was
my lord, that
disputed?
writ petition's order, my lord, was 31st of August 2012. Thereafter, my lord, the subsequent
Just a minute, let me go through the order passed on 31st
my lord,
August.
this was annexure
Page
P2,
23.
page 18. It starts from page 18.
Page 23 is the order.
My lord, my lord,
Just a minute.
my lord.
Yes.
My lord.
Yes.
My lord, thereafter I was called for interview by the newly constituted committee, my lord, district level committee. If your lordship may kindly considers, in the order dated, my lord, 31st of August 2012, the honorable court, my lord, directed that the remaining, my lord, the interview process will be conducted by the newly constituted committee on the basis of, my lord, the earlier written test. My lord, what we found, my lord, later, my lord, I participated.
That has not been stated in the order.
My lord, if
Show me
my lord,
where
may
it has been stated,
my lord, may I
recorded.
My lord, may I read
Yes,
this?
yes.
My lord, I'm reading the second paragraph onwards.
First page, second paragraph.
My lord, page 23, second paragraph.
Yes.
My lord, learned counsel for the state filed their affidavit in opposition, and from the annexure of affidavit in opposition, it appears that by order of the governor dated 18 January 2006, it was declared that the recruitment process against the post of the establishment of Gram Panchayats, Panchayat Samiti and Jila Parishad, which was started by the previous recruitment committee, shall be entrusted to this newly constituted district level selection committee for completion, my lord, for completion of the remaining process of recruitment. My lord, written test was already done. List of successful candidates was published. What the previous committee ought to have done, my lord, as per the direction, they ought to have, my lord, transferred the records to the newly constituted committee. And the new committee, the DLSC, my lord, ought to have proceeded on the basis of these successful candidates in the written examination. My lord, what we found, my lord, during our, my lord, when the list was published of the candidates who were called for recruitment, my lord, new candidate, at least 3 of them.
No, please place the
My lord,
order in its
my
entirety.
lord.
Previous recruitment committee shall therefore
Therefore hand over the relevant documents in respect of the recruitment process conducted by them to the newly constituted district level selection committee for completion of the process forthwith.
Yes.
It was also made clear that if the written test was conducted by the previous recruitment committee, the remaining of the oral should be completed by the newly constituted district level committee.
Yes, then.
So, my lord, my understanding is, my lord, the list of successful candidates in the written examination, my lord, that should be transferred or, my lord, handed over to the district level selection committee, who will, my lord, conduct the interview.
Last, it has been stated,
my lord,
in my view, the concerned respondent should be directed to
proceed in accordance with the order
communicated
under memo dated 18 January
2006,
My lord.
bearing memo number so and so.
My lord.
Place 18 January 2006 memo.
My lord, that is not available. It was, my lord, placed before the honorable court, my lord, without, my lord, any copy to us.
Otherwise, your grievance cannot be considered by this court, because it was the ultimate direction of the coordinate bench,
my lord,
that to proceed in terms of the memo dated 18 January 2006.
My lord. My lord, the
Very well, I am granting you time, serve notice upon the other side and come back with, if it is possible, with this memo dated 18 January 2006.
My lord, I will try.
Ashun. Writ petition is taken up for consideration in presence of the learned advocate representing the petitioners. However, no one is representing the respondents. Stop. Panchayat Kurmi.
My lord, Panchayat Shohayok.
Stop. The writ petition relates to selection process for engagement of Panchayat Shohayok. Panchayat Shohayok based on memo dated 18 January 2006. Stop. During course of hearing, the learned advocate representing the petitioner has placed reliance on the direction of a coordinate bench contained in the order dated 31st August 2012, passed in a writ petition being WPA 11797 of 2003. Next paragraph. Having heard the learned advocate representing the petitioners, it appears that consideration of memo dated 18 January 2006 is required. Stop. The learned advocate The learned advocate representing the petitioners has prayed for accommodation to place the said memo dated 18 January 2006 on the next date. Next paragraph. Since today no one is representing the respondents, the learned advocate for the petitioners is directed to serve notice upon the respondents or the learned advocates representing those respondents enclosing copy of the order passed by this court today by which district?
My lord, Jalpaiguri.
By 16th February 2024 and file affidavit of service on the adjourned date. Next paragraph lists the matter under the heading motion group 5 panchayat for disposal on 27th February 2024.
I'm grateful.
Next. Item number 430. At the time of call, no one appears for the petitioners and no accommodation is prayed for. Next paragraph lists the matter under the heading motion group 5 panchayat for disposal on 7th February 2024. Stop. However, it is made clear if on the adjourned date petitioners go unrepresented, consequential order shall be passed. Next, 431. At the time of call, no one appears for the petitioners and no accommodation is prayed for. Next paragraph lists the matter under the heading motion group 5 panchayat for disposal on 7th February 2024. However, it is made clear if on the adjourned date petitioners go unrepresented, consequential order shall be passed.
My lord, may I permitted to mention 4 contempt application, my lord, original side.
Arising out of the order passed by which court?
My lord Justice Lapita Banerjee, my lord.
What is the stage of the contempt?
All fresh matter, my lord.
Fresh matters.
Three of the matter returnable on 1st December, my lord.
Which one of the matters is?
Three of the matter.
Three of the matters returnable first. Rule was issued.
No, my lord.
Next Wednesday.
Your lordship, may I mention a matter, your lordship? Your lordship, this is mentioning, this is a matter relating to small tools matter, your lordship. GA number 11 passed by order was passed by the Honorable Chief Justice Prakash Srivastava on March 2022, thereby stating that a GA number 11 should be heard by your lordship. But GA number 11 is not appearing in the list, your lordship. For the inclusion of that GA number 11.
What is the prayer in GA number 11?
For selling of the Krishnagar property. The property which now is selling is now in question.
But that is the issue which has been considered by this court on last few occasions.
Yes, your lordship, but
the application is not appearing in the list. Hey, the application take করো হ্যাঁ জিএটা যখন শুনতে বলেছে জিএটা
your lordship, if your lordship pleases, then
yes, give the particulars of this application. Why you have not mentioned the matter?
I was ill, Miller, on that. I
The month of August, this was due to appear, and nobody was mentioning the matter, and this will remain as assigned matter for signed day. Ultimately, it stuck my mind, and I directed my officer to include the matter in the list.
I'm grateful to you, sir. I was not coming, Miller, last few days, Miller. That's why I don't know.
If you do not get the buyer, then the writ petition has to be heard. But how long this matter will be kept pending before this court? When it is due to appear?
On 7th, your lordship, 7th February.
দেখে নাও ওটা Call the audience side list. He will conclude within 5 minutes. He has made his submission.
All right, I have
Purushottam Lalji is Calcutta High Court larger bench judgment.
three judges.
Three judgment.
Milord, I have made.
I was under the impression that it is a Supreme Court judgment. No, it's a Calcutta High Court judgment relying upon the previous judgment of Keshav Prasad.
Yes.
And the judgment which has been considered in Keshav Prasad, this is a Supreme Court judgment.
This one, Milord, I was satisfied, Milord. I have made.
That is, this is a judgment. This has been referred to. No, not Keshav Prasad. Sorry.
Kindly see, Milord.
Just a minute.
Please see clause 3 of my note, Milord. Milord will find it. Or I have. That's why I have strung it together for your lordship's convenience. Yes.
That Purushottam Lalji, in Purushottam Lalji, Mulchand was considered.
Yes.
That is the Supreme Court judgment.
Yes.
And in Mulchand,
বের করো
One previous judgment of the Supreme Court has been referred to, that has been taken care of in Muncha. That
Mulchan deals with Abdul Samad versus
Abdul Samad, right?
Corporation of Calcutta.
Yes, yes.
That is
Abdul
Calcutta.
Samad versus Corporation of Calcutta.
That is
10 Calcutta CWN, page 182.
Yes. Or 1905 ILR 33.
And that was also considered in Lalji, in Purushottam Lalji.
Purushottam Lalji. That's why, my lord, in the note, what I have done, my lord, is kindly similar, only para 3 of my note. I strung together all those judgments.
Yes.
Just nothing further to submit, just two things. I had on occasions, my lord, referred to Muni Subrat Swami's judgment, Supreme Court, where Supreme Court took recourse, my lord, to the also interpreted the word may. There, the Supreme Court relied upon Calcutta High Court's judgment as well as another judgment of the Supreme Court. This I have referred to, I have not formally cited. I said that this is where the word may has been uniformly interpreted to be conferring a discretion. This Muni Subrat Swami is reported in 2006 8 SCC page 590. SCC page 590, just for your lordship.
That is in the context of this
Bombay Act.
Calcutta Municipal Act.
That's in the context of the Bombay Act, where the word may remains. But that may has been considered in some detail. (351) of the Bombay Act. Yes.
Your line of judgments on this point,
Para
that,
58, para
in the context of parameteria provisions, when the interpretation has been given in a different manner, that needs to be taken care of while deciding the issue, especially in the case of Ghanesham Das Supra. That was not taken care of. The interpretation which was attributed by the court in the previous occasion in the context of similar provisions.
Yes.
Now, there in those line of judgments, you have relied upon AIR 1956 Supreme Court, 1972 Calcutta AIR 459, and AIR 2007 Supreme 7 SC page 38.
That's Muni Subrat Swami. This is Muni Subrat Swami.
Yes.
The corresponding Supreme Court citation, ACC citation, 2006 8 SCC page 590. My lord, I have just handed up a short note for your lordship's consideration.
Paragraph.
Yes, Muni Subrat Swami, the Supreme Court reports paragraph is 89.
You are relying upon paragraph?
Sorry, 58 and 59 of the Supreme
58, 59
of the Supreme Court reports. That is the Supreme Court reports.
2006 8 SCC 590. SCC report 58, 59.
Bye. In fact, 57, 58, 59. I'm so sorry. 57, 58, 59. Now, my lord, therefore, yes, please, for 1 minute, please have a look at the note, my lord. Needs to be I need to be absolutely clear to your lordship, lord, because I don't want to take my learned friend by surprise. Even one judgment which I have not formally cited. Yes. Now, my lord, please see paragraph 3. I have given the long list of judgments under 1899 Act, 23 Act, 51 Act, and then the judgment
Paragraph
under the
3.
80 Act. Paragraph 3 at page 2. Now, all these judgments are referred to in Purushottam Lal. Yes. Abdul Samad is referred in turn also in Mulchand. So
Also, Abdul Samad has been considered in 1956 Supreme Court as well as in 72 Calcutta EIR.
yes, they have all been considered. Now, my lord, only one thing. That's why I've just strung them up so that it for your lordship's convenience. Second is that principle of interpretation that's at para 4. I have shown, my lord, that GP Singh page. That's the principle of interpretation. And in Mulchand, that principle of interpretation is referred to. So I get statutory validation for that principle. Para 3 and 4, kindly produce for a moment.
Now, Purushottam versus Ratan Lal EIR 1972 Calcutta, you have placed before this court from the relevant part of Ghanashyam Das, paragraph 16, if this was considered.
Yes.
But the explanation which has been given by the coordinate
Is
bench,
contrary to, cannot be reconciled with.
that, according to you, is not an
Cannot be
appropriate interpretation
in
the context of 1988.
Yes. In my reciprocal submission, my exact submission is
fact, Mr. Banerjee, that Purushottam Lalji was not considered by the not considered in Ghanashyam Das.
Yes.
It was considered.
It was considered. It was considered by a single line. It was considered by a single line, saying that because this is the 1980 Act, I will not consider. And the repeal provision,
Yes,
635.
Section 635 was taken into consideration, and it was.
Therefore, that was not in my most reciprocal submission, with great respect to his lordship, Lord. The provision that was there, the question arose was the principle associated with the word may in similar statutes. The fact that that particular statute was repealed does not take away the principle. In fact, if a similar word may comes in the subsequent statute, then the principle of law, which Mulchand itself has relied on, and I have shown, my lord, GP Singh,
which was attributed first in Abdul Samad.
Yes,
that needs to be taken.
That needs to be, because Abdul Samad was consistently followed in Mulchand. Mulchand was followed in Purushottam Lalji. Purushottam Lalji was followed in Land and Bricks. Land and Bricks also under 400. They are saying that there is the other.
That is Rai's judgment.
Yes, that is Rai's judgment. The Justice Rai said taking of money at an penal rate is an extraneous consideration, but there is a discretion. That's in answer to my lord's first query as to if it is without jurisdiction, then everything else can go to the background if it is without jurisdiction. So my humble submission, my attempt is to show that it is an action which is within jurisdiction, because the word may does give it that attribute. Second thing is, my lord, that judgment I had very humbly, my lord, I tried to show to your lordship that precedent. What is the formula for a precedent? One is if it is passed in ignorance of any provision of a law or of a coordinate bench. Second is if it cannot be reconciled with a decision of a higher bench. Now, the word may, the interpretation given by his lordship in Ghanashyam has been expressly negated in Mulchand. Mulchand, the argument was may casts a duty, therefore may should be read as shall. This was expressly negated in Mulchand. and that line of judgments followed. His lordship was pleased to cite that reason for holding that may should be read as shall in 400. The reason cited, which was negated by the Honorable Supreme Court, and that negation consistently followed by the Honorable Supreme Court and larger benches, all of which were binding on his lordship on the principle attributed to the word may, was therefore departed from by his lordship in my reciprocal submission in a manner in which they could not be reconciled with the earlier acts. Just by mere repeal, the principle does not go. If the principle went, my lord, then that part of GP Singh and whatever Mulchand had to say or other things regarding similar provisions being repeated in successor statutes would have gone. The moment you repeal it, that goes. So, my lord, this is my reciprocal submission. There is another thing, my lord, the differentiation between the statutory or whether the discretion is conferred on the executive authority or discretion is conferred on the magistrate. Whether that can be a discerning factor in order to interpret may, because magistrate is a judicial authority. Here, municipal commission is an executive authority. Is the word principle?
No, in 1972, it was upon the municipal commissioner.
Yes, but earlier it was on the
You cannot elaborate on this because 72 judgment is on it was the power was upon the municipal commission.
There, you know, this point
is in the context of 1951 Act.
Yes,
yes.
This point has been dealt with. This point has been dealt with in.
It's not required, Mr. Banerjee, because municipal commissioner power was given to municipal commissioner under 1951 Act.
51.
And municipal magistrate was there under
1923 Act and 89 Act. 1899 Act and
1899, yes.
So, irrespective of who is exercising the power, the word may receive the similar construction from there.
Yes.
Now, one more, for which I had borrowed the 10 minutes, my last minute. Just two things. This delay has created this delay of there is an approaching court. I have shown your lordship from the pleadings. I will not take your lordship again there. That
delay you have relied upon judgment, Mr. Banerjee, please don't repeat. You have relied upon a judgment upon judgments. I have taken note of that. On delay point, no further judgment. Sorry. Any other new points if you want to urge within 5 minutes or allow Mr. Dasgupta to conclude.
Yes. Now, my lord, the destruction of rights part, my lord, which I had kept open, I only wanted to cite only one judgment. If your lordship permits,
yes.
I can.
Destruction of right regarding which issue?
If
regarding
someone
what?
Again, it's connected with leches, not delay. Here it's leches. If you don't come within time, then if the period of limitation expires under regular statute,
if you find out, at least you will get 100 judgments.
So, my lord, therefore, I have
on the point of delay.
We
have already relied upon 2 judgments. Mr. Ghosh has also relied upon the judgments. Don't dilate on this issue. If you, on the point of delay and leches, you will get and acquiesce, you will get at least 100 judgments. And there are judgments, at least 50 judgments against you also.
Yes.
So therefore, there is no further necessity. You have relied upon those judgments and you have made your submission.
Only one yardstick is that if the regular period of...
Please conclude. Yes.
Just one.
Please. No further, Mr. Banerjee. I have given you enough.
Only Gurbakh Singh's judgment I wanted to place that even a void order, quoting from Wade. Just only this one and
on the point of delay leches.
No. On the point of invalidity of an order. At the wrong time by a wrong person, even a void order is valid. Unless it has been set aside at the right time by the right at the instance of the right person. Please see paragraphs 8 and 9. Only that much and I'll finish. This was the one I want. 1991 4 SCC, page 1.
Just
(1991) 4 SCC, page 1. Paragraph 8 and 9.
What is the ratio?
Lord, may I just read out? It's very short, but nonetheless, the impugned dismissal order has at
just. You are reading from paragraph 8.
I'm reading from paragraph 8 and then in fact into paragraph 9.
Yes.
Radcliffe's quotation in Smith versus East Yellow Rural District Council, an order, even if not made in good faith, is still an act capable of legal consequences. It bears no brand of invalidity on its forehead. Unless the necessary proceedings are taken at law to establish the cause of invalidity and to get it quashed or otherwise upset, it will remain as effective for its ostensible purpose as the most impeccable of orders. If this is, to add to that the corollary of delay and laches, if you do it beyond a particular period, then the court will prevent you from doing it. Second 9, apropos to this principle, Professor Wade states, the principle must be equally true even where the brand of invalidity is plainly visible, for there also the order can effectively be registered in law only by obtaining the decision of the court. Professor Wade sums up these principles. The truth of the matter is that the court will invalidate an order only if the right remedy is sought by the right person in the right proceeding and circumstances. The order may be hypothetically a nullity, but the court may refuse to quash it because of the plaintiff's lack of standing, because he does not deserve a discretionary remedy, because he has waived his right, or for some other legal reason. In any such case, the void order remains effective and is in reality valid. It follows that an order may be void for one purpose and valid for another, and that it may be void against one person but valid against another. It will be clear from these principles
If
that
a wrong order attains finality, that is applicable.
and if it is not challenged by the right person in the right
So your
proceeding at the right
contention is,
circumstance.
since there is a delay of 5 years, therefore, even if the order is wrong, that has attained finality, that cannot or not to be interfered with.
The court may not, even if it is suggested to the court that it is a void order, the court may still hold that it might be void for one, but it might be perfectly valid for another. One who has acted on the order.
But this submission with regard to attainment of finality of an administrative order, that rests upon the decision to be taken by this court whether the writ petition is barred by limitation or not.
Leches or not.
Leches or not.
Yes. So what I'm saying is, in the event my lord is with me on the issue of leches, then it will be open to my lord to hold that order, even if void for other circumstances against others, is perfectly valid qua me, because I have taken advantage of the order at the point of time when it was a legal order. I have taken steps in terms of the legal order, and those steps have culminated in certain vested rights having accrued in me, in others. Now, my lord may choose not to disturb that today by saying that it is perfectly valid qua me. So Wade is saying, Professor Wade is saying that there is that absolute voidness concept, which we had learned initially, is now subject to qualification.
Any other point, Mr.
That's
This is the additional point today you have.
Yes, this is my additional. And Muni Subrat I have cited, and everything that
you have cited. The judgment was not handed over.
But Muni Subrat was cited in the AIR reports. I given the SEC reports too.
Because it is in my note. You have cited this judgment, 2007 Supreme Court, page 38.
And in my note, my lord, I have not included this Wade judgment because I needed your lordship's leave before having the audacity to put it in my note. I have not done it. So, my lord, kindly considers it to be cited.
It is Gurdev Singh.
Gurdev Singh. Please consider it to be cited.
No, this will be considered.
Yes. Because I had promised, my lord, that I will not do what sometimes will not we do, sometimes by inadvertence, not put in judgments which have not been formally cited.
Yes.
Principle binds. In service law, it's all right. The principle binds. Now it's absolutely clear. Precedents, the ratio in the facts of the case, or the principle that can be culled out. Both are precedents.
Yes,
I'm
Mr.
obliged, Lordship. May I take your lordship's kind?
Yes.
May I just cut short the matter and very short, your lordship, I'll just give the reply.
Yes.
I was expecting, your lordship, that the corporation actually should show
their own circulars, your lordship, whether actually, your lordship, they are authorized at the pre-Ghanesham Das judgment to convert the entire car parking, whether they have a right. Because these master circulars or circulars, your lordship, are lying actually with the corporation. The legal practitioners, or your lordship, the common people at large, they are not privy to those particular circulars. Whether actually corporation is authorized, even if your lordship, your lordship Ghanshyam Das judgment, to convert the entire car parking. Mr. Ghosh, has your lordship, not made any submission. He only said the order is correct. Now, your lordship, what happened, your lordship? Finally, your lordship, I could actually find out those particular circulars. Kindly see once. I'm given a flag mark.
Circular dated circular number 37 has been pressed into service while passing order which is under challenge. Order
Yes,
dated 5th April 2012.
It's a circular number 12 of 1994-95. I don't know, your lordship, this is Mrs.
But today, if you rely upon this circular, then then I have to give opportunity to Mr. Banerjee to make submission on the applicability of this circular.
I understand, but your lordship kindly sees that particular circular, which actually
reply, don't take new point.
No, I'm not taking a new point. I have found out this particular circular, which is actually very important to see whether the corporation has at that point of time had any power at all to convert the car parking. They said that you can authorize or you can regularize the unauthorized construction, but you cannot touch car parking. You cannot touch car parking. I'll only show if your lordship thinks fit, I'll not, but this is so important.
No, in that event, I need to give opportunity to Mr. Banerjee to controvert your point.
If your lordship, I'm giving.
So therefore, take it back.
It's so important. If I may I only
not at this stage. Sorry, no new point in the reply.
Because this is not a law book, your lordship, where I can find it out, your lordship, from. May I only show?
Only you can fill up the blanks, nothing else. Not at this stage.
May
Then
I read
have
it?
to give them opportunity.
I understand. May I only read it? Then after, if your lordship thinks fit now that without this also,
we'll read it.
May I read it only? And if your lordship thinks fit, then all, otherwise I will not. This is a circular of 1994.
Yes. Read it.
The case where irregular construction have been made and a particular area of building has been put to unauthorized use by undertaking such construction, for example, conversion of parking space or other services, etc., cannot be regularized in any manner, and no compromise can be made in such cases. Is their circular. Now, however, there are buildings where no major deviation or additional construction have been done for making such unauthorized use, and the building has been in accordance with the plan, but the purpose of the use has been changed. Such unauthorized use can be considered for regularization, provided there is no conversion of the car parking space / service area.
Very good.
Now, apart from this, your lordship, the alternative remedy point, your lordship, Justice Basak's judgment, which clearly says that if the order is void, alternative remedy, your lordship, is not a, your lordship, ground. Regarding
that judgment, I have that or short judgment I have come across in while dealing with another matter. That is 2018 SCC online 15879.
15879. There are
Chittaranjan Das.
Yes, your lordship. There are huge number of judgments which clearly says that alternative remedy is not a ground where, your lordship, there is a clear violation of the principles of natural justice, or the order is completely void, or the order has been passed without jurisdiction. Now, today, your lordship, this particular authority, Calcutta Municipal Corporation, could not have the power, your lordship, to regularize that particular car parking into a lordship a office area. I've shown from the building sanction plan.
Without jurisdiction, if interpretation given in Ghanshyam Das Supra is accepted. If the interpretation otherwise attributed in the previous judgments which have been relied upon by Mr. Banerjee, then the order is not without jurisdiction.
Then your lordship, with deepest respect, then your lordship has to come to a conclusion that the Ghanshyam Das, your lordship is not agreeable with the Ghanshyam Das. Yes. And your only remedy, your lordship, lies before your lordship a larger bench.
Right.
Apart from that, your lordship, Mr. Banerjee has shown one Sanjay Mehta's judgment regarding person responsible. Those are in connection with the demolition matter. that who has actually constructed or at whose instance, your lordship, the building has been
Sanjay
constructed.
Mehta judgment, that is with regard in the context of right of audience.
Right of
Right,
audience.
but they are the tenants. Here, here the petitioners are the flat owners and car parking space
Owners both.
There's a difference.
Yes.
That I've seen.
So, Sanjay Mehta's judgment is also not applicable. Now, your lordship posed one question to the Calcutta Municipal Corporation. Whether Calcutta
I have
Municipal...
posed many questions to Mr. Ghosh, but I didn't get any reply last time. 7 except adopting the submission made on behalf of respondent numbers 5 and 6. And one judgment of the Supreme Court on delay and laches.
I say because the order speaks for itself. I did not say anything because I cannot improve anything by taking submission.
I will record that Mr. Ghosh submits that the law laid down in Ghanshyam Das Supra is par inferium.
For that, your lordship, I would like to rely on the principle of your lordship issue estoppel. It may not be a res judicata because your lordship, the private respondent, your lordship, they are hitting and saying that though principles of your lordship, the Ghanshyam Das is completely bad, all cannot be relied on, but corporation cannot say so. It may not be a res judicata because the parties are different, but it is a case of an issue estoppel. You are stopped because you have not gone before the Honorable Supreme Court and get it set aside. Today you cannot come and say, no, the Ghanshyam Das is bad. Only may I read it, your lordship, otherwise your lordship will say it's a new judgment. It's 2005 1 SCC 787 para 30. There is a distinction between issue estoppel and res judicata. Res judicata debars a court from exercising jurisdiction.
Elaborate submission and on the point submission on the point of law, there has to be an effort from the petitioner side to improve.
Yes, yes, no difficulty. The only thing is, if anything is cited anew, today itself I will distinguish it. Today itself, no difficulty.
So,
but I welcome if he cites additional judgments, improves in any way, I welcome it because this is an important matter. So anything which he wants to bring in, most welcome. Accepting facts.
Yes.
So, res judicata debars a court from exercising his jurisdiction to go to determine the less if it has attended finality before the parties where the doctrine is issue estoppel is invoked against the party.
How the principle of res judicata applies then?
Not applicable. That's why your lordship, the Honorable Supreme Court says that the issue of the concept of res judicata will not apply, but the concept of issue estoppel will apply. Now today you have lost one matter in a different litigation. In other litigation, you cannot come and say that this particular issue is incorrect. It may not be a res judicata because the party must be same. But it's an issue estoppel. Now you are stopped from raising this point that the Ghanshyam Das judgment, your lordship, is incorrect.
Yes. Any other thing?
Apart from that, lordship, Gurbakh Singh judgment, which Mr. Banerjee, your lordship, has referred, that is in connection with your lordship, the settled principles of law. Even if the order is void, I cannot say and violate that order and say, no, this particular order is void. I have to come to a court, get it set aside. For that purpose, your lordship, we are here. So therefore, Gurbakh Singh judgment is not applicable. Now, regarding your lordship, the most important factor, Ghanshyam Das's judgment. Now, Ghanshyam Das's judgment, your lordship, Purushottam Das, your lordship, has been relied on or considered. 16. Yes, paragraph 16. The Honorable Single Judge, your lordship, has considered, your lordship, the interpretation or interplay of may and shall, and has come to a definite conclusion. Now, Purushottam's judgment, your lordship, is in connection with 1951 Act, and where your lordship, a special circumstances, your lordship, has been quoted in paragraph 7. Only I am saying because he has 29th, your lordship, I have seen your lordship was passing that order in connection with your lordship, the Howrah Municipal Corporation. That paragraph 7 and 8, your lordship, Purushottam Das judgment, your lordship, has been clear that it is 1951 Act and has been given in a special circumstances. Now today, your lordship, the special circumstances is, can Calcutta Corporation, your lordship, convert the entire car parking in a commercial building?
Also in Purushottam, 1972 AIR Calcutta, the circumstances have been defined.
Completely different. Now today, what you have done? You have converted the entire car parking space of that entire building. And why I was actually, your lordship, was very keen to show that particular circular of Calcutta Municipal Corporation themselves, that even if you had the power to convert the unauthorized construction, your lordship, you cannot touch the car parking. And there is no other car parking area. I don't know. That's why I showed that Mr. Ghosh has to only say that whether this particular circular is still dead in force or not.
Both of you, whether the circular which has been referred to by your learned friend representing the petitioner is still in existence, or was in existence at a time when the issue was decided by the Deputy Municipal Commissioner dated that is the 5th April 2012 order.
Perhaps not. I mean, but I'll have to take
Mr. Ghosh.
I think Mr. Ghosh is the
Circular
best
relating
person.
to car parking.
It is regular. 93, well, after the 93, as I know, my lord, subsequently different circulars that had been issued.
Those were for limited periods. They have gone. So if he needs to say that, he needs to say that on affidavit. We can controvert on affidavit. I'm not prolonging it. I'm saying.
No.
So he has.
You have a right to say submit this, of course, because that circular was not before you.
Not yeah. If you want to say that, then we can come and controvert it. It's perhaps not.
I'll not rely on that. These are my submissions, your lordship, regarding Ghanshyam Das also. That everything has been considered. Final judgment has come. And now, your lordship, again, your lordship, at this particular point, neither corporation can take it, or your lordship, the private respondent can re-agitate the point. And only one point, your lordship, missed out that your lordship, demolition order has already been, just 2 minutes, demolition order has already been passed in connection with the roof. Your lordship, that order, your lordship, has already been, your lordship, given by your lordship, the corporation on the last day. Let this.
Yes, you are correct. There was stop work notice, and ultimately a criminal proceeding was initiated. And in 2017, on intervention of the Kolkata Municipal Corporation, that construction was stopped.
Stopped and demolition order has been passed. So this particular order may be
kept on record. This will have an impact with regard to the order dated 12
because,
April 20.
Because there are two causes of action.
Because when this order was passed, then subsequent conduct of the respondent number 5 and 6 was not in any way in existence.
I'm not on
These
that.
are subsequent events. At best, you can prejudice the respondent number 5 and 6 by highlighting the subsequent facts. That there was an affidavit affirmed in terms of one of the conditions contained in impugned order, that there shall be no further
violation
or violation. But they have violated.
They have violated. Their conduct shows that in 2019, your lordship, when Calcutta Municipal Corporation passed a demolition order, where your lordship, the private respondent not even represented. So if your lordship allows, your lordship, this order, your lordship, of the corporation may be kept on record at the time of final adjudication. I'm grateful, your lordship. These are my submissions.
Hearing is concluded. Judgment is reserved. Okay.
Regarding that issue estoppel judgment, issue estoppel doesn't bind me.
No, I'm not saying you. I'm saying Mr.
So I just want to distinguish one line. He said res judicata is between the same parties or persons claiming through them litigating under the same title. That's section 11 of the CPC.
Yes.
It binds them as an inter partes judgment. Even the persons litigating under the same title as an inter partes judgment. This would not have the effect of res judicata, but according to him, because corporation is one of the parties in Ghanshyam, it will be issue estoppel on the corporation to say anything contrary to what Ghanshyam ultimately holds.
Sorry.
If he has not carried it in
That's why I have asked Mr.
My lord's first query. At the moment my lord asked my lord, immediately my lord, that bell rang.
This issue might be open to you to urge before this court.
Yes.
But so far corporation is concerned.
That's why my lord came down heavily.
Adopt your submission.
My lord came down heavily on the corporation only on that ground. Only, so that issue estoppel part does not invalidate my humble.
Binds corporation, since corporation was party before the coordinate bench when Ghanshyam Das was decided.
And it was open to the corporation to take it up higher.
I'm grateful.
Yes, next one.
I'm grateful. Your
Item number 2, my lord, I'll be requesting your lordship for a week's time. Perhaps, my lord, steps may be required to be taken. Because of
Steps means
required to be taken. I've heard that maybe the petitioner is no more.
you are representing
Petitioner in this. But I am not sure. I have not yet. So therefore, my lord, I don't want to cite it as a reason.
Simply not today.
Simply not today, my lord.
My lord, I'm for the petitioner, my lord. On the last occasion, 20th December, my lord had passed an order directing the respondent number 7 to grant
Let me see the order.
grant a fresh hearing, my lord. They have given a notice to
Just
conduct the hearing.
Which order you are saying? 20th December 2020.
Yes, my lord. Page number 3, my lord, operative portion.
Just.
Corporation. Judiciary hearing.
Yes. What is the order?
Lord, hearing was fixed on 2nd February. My lord, notices were sent.
Yes, my lord. That is the thing. They have sent a notice on 30th January, my lord.
Why delay in spite of this order passed by this court?
Lord, delay
When the matter is fixed by this court?
Yes.
How respondent number 7 dares to do this?
Lord,
it's a contempt.
your
It's a pending writ petition. Within 4 weeks, there was a direction to pass an order after hearing the parties. Matter was hearing of this matter was adjourned for 6 weeks. And how this
what
how
happened
this
in
delay?
But your lordship passed this order on 20th December, directing us to communicate it on 22nd. My learned junior was sick.
But I have communicated the order
Learned-
by myself.
Show me the communication.
This is my communication. Learned junior was sick, and thereafter, winter vacation. Thereafter, I communicated
I
the
have
order.
communicated on 21st December
I
itself.
communicated the order. On
দেখাও তো আমার কোন communication টা।
This is my communication, on 10th.
You have made the delay in communicating the order, but they have communicated it to the Director General West Bengal Fire and Emergency Service on 21st December 2023. Order was 20th December 2023.
Kindly pardon him, kindly excuse him, and he said order would be passed,
So, the writ petition is taken up for consideration pursuant to the order dated 20th December 2023 in order to find out the order which is required to be passed by the respondent number 7, which is required to be passed by Director General, West Bengal Fire and Emergency Services, being respondent number 7, pursuant to the direction contained in the previous order. Stop. It has been specifically spelled out in the order dated 20th December 2023 within a period of 4 weeks from the date of passing the order on 20th December 2023, Director General, West Bengal Fire and Emergency Services is required to pass order. Stop. Next paragraph, Mr. Mitro, learned advocate representing the respondent number 7, has placed before this court one hearing notice dated 30th January 2024, wherefrom it appears that the respondent number 7 has fixed hearing on 2nd February 2024 at 12 noon, which is beyond the prescribed time. Next paragraph. However, date and time has been fixed by the respondent number 7 in terms of the order dated 20th December 2023, albeit belatedly, this court is restraining itself from passing any order against the respondent number 7 in order to permit the said respondent number 7 to complete the exercise, which is required to be carried out in terms of the order dated 20th December 2023. Stop. Hearing of this matter stands, next paragraph, hearing of this matter stands adjourned. till 28th February, 28 February,
But any day other than my personal difficulty, my lord, on that day.
because in the midst, this court will not be available for 2 weeks.
Yes, my lord, I'll say.
28 February 2024. Stop. On the next date, the delay made in passing order pursuant to the order dated 20th December 2023. So far, Director General, West Bengal Fire and Emergency Services is concerned, is to be considered in the context of the order to be passed by the Director General. Next paragraph. The hearing notice dated 30th January 2024 and the communication made by the learned advocate for the petitioner upon the Director General intimating the order dated 20th December 2023 are taken on record.
Only thing, may I take a picture of that intimation?
Yes.
Because I do not have.
You take a photocopy and then submit the original copy.
Yes.
Mr. Mitro,
Lordship,
take
yes.
steps. Otherwise, your Director General will be in soup.
Lordship. Lordship.
For matter, it's my application, contempt matter.
First time.
Yes, my lord, for the first.
Let me see what was the order passed.
Yes.
Is it an arbitration proceeding?
Yes, my lord. It's Section 9 application, orders passed, my lord. One order passed, my lord, on 8th of September 2022 by Honorable Justice Saraf, my lord. Thereafter, my lord, against that a contempt proceeding was initiated. In that contempt proceeding, my lord, ultimately the contemptor hearing, my lord, he came and he tendered an unconditional apology and saying that he will not do it again. And that was also reflected by the order dated 4th of
This
July.
is a second contempt
Second
in connection
contempt.
with the same order.
Yes. And again,
So, are you complaining of the violation of the order
the
passed in the first contempt
Both
or
the
the
orders.
order passed in on Section 9 application?
Both the orders, my lord. Both the orders, my lord.
Show me where is the
Yes,
contempt?
my lord, first order, my lord. May I show the orders first, my lord? Order, my lord, page 105, volume 1, my lord. It's supposed. First order, my lord.
This is 8 September.
Yes, my lord, 2022.
That is the first order.
That is the first order, my lord.
Passed on Section 9 application.
Yes, my lord.
Where is the relevant part?
Relevant part, my lord.
Just
Is
in
the-
this, a short order, just in. Whether the Section 9 application has been finally disposed of
No, my
after
lord.
exchange
It's
of
still
evidence?
pending.
Still pending.
Still pending. my lord.
And what about the Section 11 application?
That is also pending, my lord. Both the applications are pending.
So there is no naming of arbitrator.
No naming of arbitrator till date.
Show me prayer C.
Prayer C, my lord, it's at page 102, starts at page 98. The relevant prayer C is 102, page 102.
Contemner has to be heard.
Has to be, my lord, in each contempt, my lord, has to be heard. And my lord, page 203.
It has to be ascertained whether there is a violation of the terms and
Yes.
conditions of the development agreement or not.
Yes, my lord.
Where is the violation?
No.
And that is an interim order.
Yes. But my lord, page 203, my lord, if your lordship takes up the order at page 203.
The subsequent order which has been passed in the first contempt proceeding.
Yes, my lord. Page 203, second volume, my lord.
203.
203, my lord. Just like correction, my lord. The order was corrected by another order of 7 July. Petitioner wrong.
The contumacious contempt by the petitioner, that has been corrected.
No, yes, petition. Yes, yes.
The next order. So for your second contempt is concerned, what is your grievance? What is your allegation against the alleged contempt?
Contemner is he is threatening my man, he is abusing my man, he is stopping my work of construction. Ma'am, page 206, madam, I made a.
Because already they have the contemners by filing an affidavit has admitted their wrong, and they have tendered apology.
Yes, they are.
The result whereof, in consideration of tendering apology, the first contempt application was disposed of with a direction that in future there will be no hindrance in extending electricity or supplying electricity to the to the petitioners.
All development works, including the electricity.
Now beyond this scope, whether there is any further scope in order to beyond the scope of this order dated 4th July 2023,
no,
is there any further scope to examine whether there is a contempt or not?
Yes, my lord. Why, my lord? Subject to correction.
The second the order passed in the first contempt application is very relevant. Read the order at page 203.
Yes, my lord. May I read from the, my lord, second paragraph?
No, first paragraph.
Prima facie, from the documents that have been annexed to the contempt petition and the affidavits exchanged by the parties, this court was of the view that there has been deliberate contumacious contempt by the petitioner and respondent. However, the contemners have, by an affidavit dated 26 June 2023, tendered an unconditional apology and sought pardon from this court for their disobedience. In light of the same, this court does not wish to proceed any further or pass any adverse orders against the contemners. However, the contemners are directed not to, in any manner, it's important, my lord, prevent the petitioner from carrying on the legitimate work that they are doing, including obtaining electricity connection for the building. If it comes
now,
to the
what is your allegation?
My lord, my construction work is going.
Yes,
one block, two blocks, three blocks. Yes, 3 blocks. There are several blocks, my lord, one after one. He's coming. He's threatening my man. He's stopping my work that he cannot do under the contract, under the development agreement. That he cannot.
How they are threatening?
Threatening my man, abusing my man. My lord, it has so happened, not after this, but even before this, my lord, he beat up my man. He was to be hospitalized. And here, my lord, page 206, my lord, this is the general. And he was under custody, my lord. He's in bail. He's
in this
left in bail.
contempt application, petitioner alleges violation of the order dated 8 September 2022, passed in AP 507 of 2022, and
4th July.
order dated 4th July 2023, passed in the first contempt application being CC 69 of 2022, which has been corrected with a subsequent order dated 7 July 2023 by the coordinate bench. Stop. Next paragraph. The learned advocate representing the petitioner is directed to serve notice upon the alleged contemptor, enclosing copy of the order and the copy of the contempt application, a copy of the order and copy of the contempt application by fortnight from date, and file affidavit of service on the adjourned date. Stop. Next paragraph. List the contempt application under the same heading for further consideration in the for further consideration on (6th March 2024).
Great. Great.
Next.
Item number 5, my lord, I'm a claim for the petitioner and labor Mr. Devdapta Sen.
Yes.
My lord, I'm not seeking time. He's on links before courtroom number 16. Till then, my lord, kindly bears with me. If my lord wishes, he made a detailed argument on the issue. On the last occasion, my lord has raised one query.
You have to start from the beginning, because there was a stand taken previously. Subsequently, the stand was different. So therefore, this issue has to be made clear before this court.
My lord wishes the entire argument to be done freshly.
Yes.
Otherwise, my lord, it will be difficult.
My lord, then kindly.
You might be under wrong impression, because on the first day, in a separate way, the matter was proceeded with. So far the petitioner is concerned. Subsequently, the stand was made different. Mr. Sen argued on the basis of that stand, but the hearing could not proceed further.
Proceed further.
Therefore, the issue has to be re-agitated before this court in order to appreciate the grievance of the petitioner.
My lord, on the last day, my lord has observed one.
Not today.
Your lordship, my lord, prima took a view, then your lordship, my lord, asked
Yes,
my lord
yes.
to.
Then Mr. Sen developed other points.
Yes.
In order to
Therefore, in order
answer
to,
the query
yes,
of the
in order to my lord, scope of the writ petition and what is the order, and it is to be ascertained my lord first.
My lord, because alongside what has fallen from my lord, there was another point taken up that another point that has fallen from your lordship.
Yes.
That was why the delay of so many years. Because they have retired on 2012 and the writ petition was filed on 2017.
Yes.
And my lord wanted to know whether
Yes,
there
correct.
were any representations. My lord, I have made a note about upon the number of representations by them, which begins from 2010, when they were still in employment.
But then your contention is this, that several representations have been made.
Already been made, yes.
But making of representations will not be an explanation for delay. There are judgments.
Judgments which. But any which way, my lord, kindly, since Mr.
That will not be an explanation for delay. Making one after another representation will not extend the period of limitation too. Though strictly speaking, in writ proceedings, Limitation Act does not apply. But the Supreme Court is saying that ordinarily the writ petition should not be entertained after the expiry of 3 years.
Yes, ma'am. My lord, in that case,
See the judgment of Pan Singh and Sibdas.
Pansing and Sivdas.
Pansing and Sivdas. In Pansing, Sivdas was considered.
Yes, my lord. Then since my lord wants to hear, wishes the entire repetition to be, then I'll
So
come back
therefore,
next week.
explanation will not be an preferring of representation will not be an explanation of delay. If the claim of the petitioners has been converted into a stale claim, in that event, life cannot be injected in the stale claim.
My lord, I should better not make any comment on this. Let Mr. Sen come and then. Very unfortunate matter. Both the matters are taken up simultaneously.
Not today. Mr. Ghosh, not today, no order. কোথায় বিমলবাবু কোথায়?
My lord, on the other note, just outside the purview of the writ petition, my lord, there are Supreme Court judgments also that say that the valid reasons for delay with regards to representation saves the client's, the petitioner's life of for filing of the writ petition. I had.
Yes, there are judgments against which supports the in certain facts and circumstances the explanation which is being offered in order to explain the delay.
Here in this case, the different situation.
Yes.
His representation had been taken into consideration and his claim was rejected on certain incorporated certain ground.
Very well, let
I'll
Mr. Sen
come back. Yes, ma'am. Oblige,
He will assist Mr. Sen at a time when Mr. Sen will advance argument. Dako. There is use of calling appellate side matters again. 3:30, there is a 3:30. Because advocates remain under the impression that no further appellate side matters will be taken up since 3:30 matter. Resolution is there.
To be I place